We got everybody. All right, well, good morning. We will start this second day of our Joint Judiciary Committee meeting here in Cheyenne on Tuesday, September 14th. Good to see everyone this morning. Thank you for spending the day yesterday with the district court judges and understanding their challenges as public servants in the judicial branch. I think that was a productive day and evening. And so those of you who participated, thank you for making the time to learn more about our other branch of government and those that serve in that capacity. So this morning, I think what we're going to do is my co-chairman thought it would be a good idea to follow up from where we were yesterday. And I support his thoughts on that. To have LSO kind of go over briefly the high level memos that we had prepared for us for yesterday's agenda. Yesterday was a long day and we were getting a little bit later into the evening before we adjourned. And so this morning, while we're fresh, we can kind of hear that information and maybe discuss it this morning. So with that, Mr. Fuller, if you'd like to walk us through some of those memorandums.
Co-Chairman Nethercott.
Co-Chairman
Actually,
Olson.
real quick, can we have Mr. Fuller just give us a summary of our actions yesterday so that he's clear on instructions and doesn't have.
We do that at the
That's-
end of the day.
Right,
today.
that's what that's what I was trying to communicate, is that we ended yesterday with Mr. Fuller. I gave him the instruction to give us a couple minutes this morning, just tell us what he had, as opposed to yesterday.
We
wanna
usually do
both-
it at the end of the second day.
You want to do both days?
Mr. Fuller agrees. Yes, we do it at the end of the second.
Oh, that's fine.
Okay. So with that, we will start with the order of business for the day, which is non-compete clauses. Representative Stith, I understand maybe you're on Zoom. We'll let you in now.
Good morning.
Good morning, Representative Stith. Great to see you.
Good to be here. Thank you.
Do you want to walk us through the non-compete?
Sure, I'd be happy to. That is 22 LSO 118. The broad structure of it, and it is a big policy step, the broad structure of it is to outlaw non-compete clauses in most situations. The idea would be, and then to create some exceptions relating to essentially the sale of a business or a partnership interest. So on page 1, top of page 2 begins with the definitions of business entity, which essentially is defined as a partnership, as corporations and limited liability companies. Staff appears to have recommended that we include sole proprietorships. That makes sense to me as well. And I think the idea being here that if a person were selling their dry cleaning business and the purchaser of that dry cleaning business in a small town might have a legitimate interest that the seller not compete with them in the future, that they just retire or go elsewhere. That's probably a fair expectation. And I think what staff is saying in its comment on page 2 is that it really shouldn't matter whether that dry cleaners has decided to organize itself as a corporation, an LLC, or as a sole proprietorship. So that makes some sense. Excuse me. Bottom of page 2, owner of a business entity, just includes the partners, the members, etc. And then page 3 deals with other ownership interests. Line 6, ownership interest means, and then it has the definition, which is pretty much what you'd expect. Line 16 through 19 has a definition of specialized training that relates to another exception that you'll see later in the bill, which is the idea that although we may want welders and plumbers to be free to practice their profession and not be subject to non-competes. Nonetheless, it's really important to be fair to the employer, so that if they pay an extra $10,000 to train a welder to do hot tap welding or something like that, get a specialized certificate in live, natural gas in use welding, that the employer has made some kind of investment. And if the person leaves within a certain period of time, the employer could say, hey, I trained you, you've got to pay me back. Definition of subsidiary on page 3. In small businesses in Wyoming, you don't see that a lot, right? We don't typically have really complicated corporate structures here, but it basically just wants to make sure that regardless of how you organize your corporate structure, the rules are going to be the same, essentially. Page 4, lines 9 and 10, is a definition of substantially all. And again, I apologize if there's background noise. The city has a construction project ongoing next door, so I apologize if there's a bit of drilling going on. Over the past 4 months, I've gotten to where I don't hear it anymore. So on substantially all, the idea is that a non-compete clause should be reasonable in the event that you are a seller of substantially all of the assets of your business. And the question is, well, what is substantially all? And staff has sort of put in as a placeholder the term of 80% here. I think that probably makes sense. That's just, obviously be up to the committee to decide what number you want to put in there. 80% is consistent with the Department of Revenue rule relating to bulk sales. And I had sent an email to the members of the committee last night suggesting that we fine-tune this definition of substantially all to exclude cash and cash equivalents. To use the dry cleaners example, let's imagine you're buying the dry cleaning business and the assets of it are worth $7,000, but they've got $3,000 cash in the till. Well, normally when you're buying the assets, you don't buy cash, right? Because it's pointless. If they have $3,000 cash in the till, the buyer could theoretically give $3,000 to the seller, and the seller could give the $3,000 cash right back, but that's kind of pointless. So people don't do that. The Department of Revenue, for purposes of determining whether something is a bulk sale or not, counts the cash. And the problem that creates is, in the case of Delcon Partners, is that this purchaser of a business ended up having to pay sales tax on a bulk sale. And so that's unfortunate. So it's recommended that we perhaps add a sentence, perhaps after this definition of substantially all, to say something to the effect that substantially all with respect to assets shall not include cash or cash equivalents. That's just a suggestion for the committee to think about. All right. Page 5, lines 15 through 20. That's the part of the prohibition here. So it's worth, I suppose, reading. Page 5, line 15, any provision contained in any contract by which a person is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void, except as otherwise provided in this section. The voiding of one or more provisions under this subsection shall not affect or render the remainder of the contract invalid. So that's the basic, prohibition, right? And then the rest of the bill really is subsection C, starting page 5, lines 22, and over the next couple of pages deals with the exceptions. And so there are essentially two broad exceptions, as I kind of mentioned. The exceptions are the employer's actual expenses paid to third parties for specialized training in the event that the employee separates from the employer and works for a competitor within 2 years of the receipt of the specialized training. Staff has recommended perhaps that the committee delete the phrase works for a competitor in line 12. That probably makes sense, as it's a bit redundant and might, I don't know, you can think about that. I guess I don't have strong opinions one way or the other. And then bonuses. If you pay a big bonus to somebody and then they immediately leave, well, if your contract with the employee had a clawback provision, that would still be legal. Then page 7, line 17 and so forth, essentially talks about what happens when a person decides to get out of a small business. So if you're a member of an LLC, you could agree to be bought out, and as part of agreeing to be bought out of the business, you would agree not to compete. And I think that's reasonable, because as an owner of the business, you've got some control over your future. You wouldn't have to agree to that. That takes you through really about to page 9. So page 9's lines 7 through 10, I think, are important. This is the exception where a person sells all or substantially all of the business entity's operating assets or the operating assets of a division or a subsidiary of the business entity together with the goodwill of that division or subsidiary. I don't think we have a definition of operating assets. Perhaps that is sufficient enough to deal with my prior concern. And I guess thank you for listening. And do you have any questions for me?
Thank you, Representative Stith, and members of the committee, Representative Stith and Mr. Fuller. I just called on Representative Stith because this is kind of his concept that he has presented to the committee to consider, and knew he certainly had the skill set to walk us through the bill and also share with us his comments for time efficiency. But with that, I'll call on Mr. Fuller and see if Mr. Fuller has any other comments about the drafting of the bill or any other staff comments that should be addressed.
Yeah. Thank you, Madam Chairman. I think the only other note I would raise is on page 7 and the language on lines 1 to 3 regarding, an agreement for, an employee to reimburse an employer for the employer's actual cost of a hiring bonus. And the staff comment is just geared at, any number of places could offer a hiring bonus, and whether there should be some limit placed on that. For example, a hiring bonus given for a specialized skill versus a hiring bonus given to work, at a local market or fast food restaurant.
And Mr. Fuller, I see also with our materials is a recent Supreme Court opinion from July 15th, 2021. So this summer, representing the appellants is Clark Stith, Esquire, Rock Springs, Wyoming. And so no doubt the experience from this case has brought this issue forward, Representative Stith, and this concept is pretty consistent too with our work on reviewing Supreme Court opinions and understanding responses that the legislature may want to make in response to those. So Representative Stith, any comments on your case? The Supreme Court's opinion. Do you agree with the opinion?
Madam Chairman, thank you very much. I appreciate it. I won't talk too long about that, but yes, it's always good to win. And I think it points out what's interesting about the state of the law right now is that it's not that the law right now is wrong or bad. It's just that it's messy and complicated. There's a 12-factor test. And so in that particular case, you had 3 nurses who were, essentially put out of business, 2 of whom left the state during the coronavirus pandemic. Very unfortunate that the law at that time kind of allowed the district court judge to boot them out of the county. And what the case narrowly stands for is that a judge in doing so needs to consider harm to the public if the judge is going to enter an injunction like that. So, and I think the Supreme Court got to the right result, but it's all very inefficient, right? Because you had, of course, the time for appeal. During that time, patients are not getting the care that they otherwise would have gotten, theoretically. And it's all quite inefficient, right? Lots of lawyers' fees. And the current procedural status right now is that my clients are asking the district court judge to award them damages for the fact that they were involuntarily unemployed for 10 months. So I think what the opinion points out is that it's not that the law is wrong, it's just that it's complicated to the point that it has this undesirable social consequence that we have people that, for example, get trained at Western Wyoming Community College as a nurse. We put all this money into training them. And then if they have a falling out with their employer, the effect is they get booted out of the state, or can be. So I was happy that in this particular case, in the case of Best Home Health versus Brown et al., that the nurses are allowed to go back to work, and at least two of them have, are working right now as nurses in UNT County.
And so Representative Stith, how, if this bill were law, how would that have been different from the nurses in this case?
Madam Chairman, thank you for the question. The big difference would be that the contract that was, or the document that was presented to them, ostensibly having them promise not to compete with their employer, that would just be void. That would be unenforceable. And so employers would not be allowed to do that at all. As a result, the employer in this case, who may have been disgruntled that the employees left its employ, would not have been able to file this lawsuit, would not have been able to have gotten a preliminary injunction. The employer would retain, under this bill, and this is important, the employer would retain the right to sue and to obtain a preliminary injunction for misappropriation of trade secrets, for misappropriation of confidential data of the employer, and also for solicitation of the employer's customers or clients. This bill before you today does not affect any of that. What it does affect is that it outlaws the blanket covenant not to compete.
Representative Oakley?
Thank you, Madam Chair. Good morning, Representative. I'm just wondering if you think that there is room for maybe a compromise here, rather than a straight prohibition, because it seems to me, rather than a prohibition and then this discussion about paying costs back, which also could be complicated, messy, litigious, maybe we could find a compromise where, and I mean, tell me, obviously you've thought a lot about this, what you think about it, but where we shorten the time and maybe only have it initial, because I think one of the issues is renewing, rather than having it that somebody's a new hire and genuinely paying back maybe some of the training that they received, that sort of consideration. So it seems to me that maybe there's a Goldilocks solution here, rather than a straight prohibition, but greatly narrowing what they could do. That it takes both of the interests I see from this case. The Supreme Court saying there's two competing interests here, right? The freedom to contract and the freedom to work, and that maybe we could find something that's more of a compromise in the middle. What are your thoughts on that, Representative?
Representative Stith?
Madam Chairman, Representative Oakley. Well, there's always more than one solution to a problem, so I wouldn't want to out of hand dismiss trying to find some other different compromise. Right now, in this balance between freedom to contract and freedom to work, typically the employee doesn't have much bargaining power, right? Because they need a job. So employees are in slightly different situations. There's perhaps a difference between the employee who's just out of school and who really needs the training, with a veterinary clinic, for example, and that training is extremely valuable to that employee, where it sounds like it's somewhat more fair to require that they not compete right out of the gate, in contrast to, say, someone who's already been a veterinarian or already been a nurse for 30 years and then gets a job. So I guess I lack certain imagination about exactly how to address that. For lawyers, for example, it's my understanding that law firms are not allowed to have covenants not to compete, that not as a matter of statute-based law, but as a matter of the rules of professional conduct, that we're not allowed to tie the hands of our associates. That if I hire an associate, that person is free at any time to quit and compete against me. I think that's the current state of the law for lawyers. I don't think that the law profession, as a result, fails to train its lawyers. So from a public policy point of view, since the state is putting so much in resources into developing human capital through our university system and through our community college system, while recognizing that employers also provide valuable training to them, I just think that covenants not to compete aren't really serving a useful economic or social purpose. States that have outlawed them, such as California and Oklahoma, and to a different extent Colorado, don't seem to have suffered. It seems like it provides more fluidity in the labor market to outlaw them. I guess Colorado does represent a compromise, because in Colorado, they banned covenants not to compete, it's my understanding, but it's not a blanket applicable to all employees. It applies, the prohibition applies essentially to blue collar workers, but management personnel can be still subject to covenants not to compete. Is that a fair solution? I don't know. I guess I apologize that I've given you kind of a quite long answer here to basically say I don't know, and I think maybe the utility of covenants not to compete is pretty limited, and so I think maybe it's time for them to go.
Representative Stitt, thank you for that response. And I think it's fair that you don't know, that there are policy questions. And I think it's important to recognize some of the work of the interim committees is to have deliberative discussions where we don't necessarily know the answers. And it's not, I like this, I don't like this, vote aye, vote no, where we're actually just engaging in the dialogue and the debate so we can flesh out these issues and understand what may work or what doesn't work so we can get to the right result. So thank you for your candid answer and bringing this issue forward. Further questions for Representative Stitt? Senator Cole.
Thank you, Madam Co-Chair. Representative Stitt, on page 7, lines 1 to 3, you kind of brought up a question about this area. And I guess the 2 years that you have listed here, do you feel that's still a good, fair compromise at this point? Or would you want to change the sideboards at all? I guess I wanted to hear what you had to say about this with more explanation, possibly. Thank you, Madam Chair.
Representative Stitt, just to pile on this as well, I feel uncomfortable about this bill, primarily because it evades into the freedom to contract. I do think Wyoming needs some solutions on this front, but this seems pretty specific and really evading into the province of the freedom to contract. And we put in a specific time period like the 2-year piece. So if you address both of those concerns, if you could, please.
Madam Chairman, Senator Cole, the 2 years, of course, is just there's nothing magic about that time deadline. So this is a situation dealing with where you've paid a hiring bonus to somebody, right? So there's a certain fairness, I think, in what you want to avoid is someone, say a doctor, who our local hospital, I think, pays extremely substantial bonuses to attract them. I mean, it can be a couple $100,000, right? That our local hospital will give to a doctor to attract them to uproot their lives and move to Rock Springs. I think that does happen. And so you don't want to, if a doctor like that 6 months later then just jumps ship and opens their own medical office across the street, then the hospital will feel like that it didn't really get the benefit of its bargain, or certainly lost the value of the hiring bonus. At some point, the employer, in doing a hiring bonus, they're amortizing their expectations. They don't expect every doctor they hire to work the entirety of their careers at the hospital, right? They don't expect that a doctor is going to be an indentured servant, I don't think, or they shouldn't reasonably expect that. So there's some time limit, say between 2 years and 30 years, that I think would be appropriate, over which they are amortizing the cost of their investment of the hiring bonus, right? 2 years may be a bit short, maybe make it 5 years. I think it makes sense to have some limit, because let's imagine that they pay a $200,000 hiring bonus to a doctor. The doctor comes, works for the hospital for 20 years, and then goes across the street to set up their own private orthopedic practice, for example. It would seem onerous, after 20 years to demand disgorgement by the doctor back to the hospital after 20 years. That might, again, create too much friction in the labor market, right? That is, keep someone stuck to an employer longer than they should be. So 2 years may be short, maybe 5 years is more appropriate. But I think it makes sense to, in fairness to the employer and the employee, to have some time limit on it.
Representative Rodriguez-Williams.
Thank you, Madam Chairman. Representative Stiff, just to piggyback on Senator Colt's question, referencing page 7, lines 1 through 3, with the 2 year of initial hiring piece in there. What I see happening in my community and a lot of other tourism communities is those that are employers in the hospitality industry are contracting and giving hiring bonuses to just work summers. And as you know, we have a workforce shortage in the hospitality industry, restaurants, hotels, et cetera. And so I'm a little concerned about the years being in there, just thinking about a different workforce sector.
Representative Stitt?
Madam Chairman, Representative Rodriguez, that makes total sense. You pointed out a great issue there, that you have a problem on the other side where it's 2 years is too long, right? I think for temporary hires, the idea would be that, at least it's implied in the bill, or maybe it should say in the bill, that if the employer is laying you off, right, or if they're hiring you for a definite term, namely, I'm hiring you for the summer of 2023 to work at this national park or this state park, that, and here's your bonus for working for this term, that it wouldn't make any sense to try to allow the employer to, claw back the the bonus after the end of the season, right? I think that problem in practice wouldn't arise, because this provision shouldn't apply if the employer is laying you off, which is what happens for temporary hires. If I may add a word about freedom to contract. Freedom to contract is great. Okay, it's a value, it's a positive value that we don't want the government interfering too much with, but it certainly has limits, right? It's not an absolute principle. 120 years ago, the United States Supreme Court at that time struck down minimum wage and maximum hour laws, right? For bakers. Bakers wanted to work 40 hours a week and be paid a certain wage. And the US Supreme Court in the Lochner case said, well, no, you can't have a state law that limits the hours that people can work in a week, because that interferes with the freedom to contract. So in our labor laws already, by having a 40-hour work week, and if you work more, you have to be paid overtime. Laws banning child labor, for example. Those are all laws that impinge on the freedom to contract. So I think it's important to keep the freedom to contract value in perspective, and where there's disproportionate bargaining power between the parties, then your freedom to contract isn't very effective for the person who doesn't have any much bargaining power. Thank you.
Excuse me, Representative Stith, I'm so glad you recently briefed these issues and have argued them to the Supreme Court. You are on the ready, and I appreciate that expertise that you have to share with the committee today. Those are really thoughtful comments. Further questions for the representative? Co-Chairman Olson.
Thank you, Co-Chairman. Representative Stith, I just want to bounce back to the year concept and tying that in with what you just talked about on the freedom of contract. So I think I will agree with you that freedom of contract has a reasonable restraint portion to it. At some point, it's not an unfettered concept or right, as all rights are when we live in a society. So my question is, I don't know a lot about this area, but you definitely do. So looking at the standard, which would be, I believe, what most states would use is a standard like, is the duration reasonable? Something to that nature, that would be the test. And that would help us, that is a restraint, right? So that I don't know if a state would find that a 20-year non-compete was reasonable. Maybe a court has. That's really my question to you is when we're looking at the duration as just one of these areas that we can hone in on, as Representative Oakley was, what is reasonable? What has been found reasonable in Wyoming, but more broadly across the nation, is there a pretty set standard? Meaning, I think your 20-year example, I would again venture to say most courts would find that unreasonable, but where is the reasonableness? And that might help us to hone in a little more on that duration concept.
Representative Stith, do you have a summation of Wyoming Supreme Court precedent or national precedent on kind of an average of reasonableness?
Madam Chairman, Co-Chairman Olson. So here's where I think we need legislation so that people will know what the law is. Because in Wyoming, as Co-Chairman Olson pointed out, covenants not to compete right now have to be reasonably limited in geographic scope and in time, right? So, but what is that? No one really knows. So covenants not to compete of up to 3 years have been held to be enforceable. But in at least one case in Wyoming, the Supreme Court upheld a lifetime ban on running a bowling alley to compete with the plaintiff. So, you have everything from 3 years to lifetime is reasonable, according to the Wyoming Supreme Court, depending upon the facts of the case, right? And so that's the standard that I think is unworkable, right? Generally speaking, I think in the business community, people or like lawyers, I think, drafting these things tend to think that, typically for covenants not to compete under existing law, if you have a 1-year covenant not to compete, that's pretty solid, very unlikely to be struck down. 2 years, same thing. 3 years, probably. 5 years, maybe. And so that's just the sort of the feel of it. And yet there's so much uncertainty involved in it that it tends to lead to litigation. This particular provision on page 7 is dealing with the 2-year time limit, is of course not dealing with the 2-year time limit of a covenant not to compete, but rather with dealing with the time limit for a clawback of a hiring bonus, right? Which is a slightly different issue. And on the clawback of a hiring bonus, to me, what would be reasonable would be to make the time long enough that the employer should have been able to have realized the benefit of paying the hiring bonus. Does that help? Maybe, I think when businesses are doing their future business plans, I don't know a lot of businesses that have 20-year business plans, right? But you might have a 3 to 5 year business projection. And so to me, it would make sense to make on page 7, lines 1 through 3, maybe make that 3 years, 5 years, something like that. I think some limit is appropriate because to me, it just seems like it would be a bit outrageous to have a contract clause that said it's unlimited, that we can claw back our hiring bonus, just into the foreseeable future forever. That would really take away the benefit of a hiring bonus, right? I mean, what's the point of having a hiring bonus if you had to always pay it back, right? So, thank you.
All right, thank you, Representative Stith. With that, I think, stay close by. We have about 20 minutes left on this topic. I'm going to flip to public comment on this and then move it back to the committee and Representative Stith. I think for purposes of this bill, it'll be helpful if you stay on for the committee's discussion as well. So is there any public comment on this bill? I don't think there's any online. And so any in the room? Yes, come forward, Mr. Bully. I was wondering if you'd be interested in this topic. Yeah.
Good morning, Madam Chairman, Chairman Wilson, committee members. I'm Eric Bully, President of the Wyoming Hospital Association. And I spent the night worrying about Title 25. I didn't realize how broad the net would be on this one, but walking in and hearing hospitals brought right into the talk or the conversation. I would just make the committee aware that 3 years ago, I think it was, there was an attempt to do something similar to this that was specific to physician contracts that went through the Joint Labor Committee. There are some good points that Representative Stiff brought up, but there are some concerns obviously we'd have on timeline. I think one of the things just to set the stage as we look at timelines for limits on these things, our WWAMI students have a 3-year obligation to stay and work in the state to have their student loans repaid. So 2 years is obviously way too short. I think the other thing from a hospital and a physician perspective to consider is, yeah, there are significant expenses, not just signing bonuses. It takes a long time and a lot of money to help a physician get established in a community. There are a lot of expenses incurred other than that, relocation expenses, along with the signing bonuses. Sometimes there are student loan repayments that are attached to their employment, hiring staff, tail coverage insurance for malpractice. There are a lot of them. So I would be very hesitant to say that 2 years is adequate time. It normally takes them more than a year probably to really start to even cover their expenses. So the other thing that I would add is that there are very elaborate ways and there's a lot of work that goes into the contracts between a hospital or a clinic and the provider. There's the ability to renegotiate those contracts. It's not an ever-ending contract that renews automatically. Reimbursement or compensation, all those things are looked at annually, and the providers have that opportunity to renegotiate. I think this is a pretty broad bill that is all encompassing, and I think this would deserve a lot more work before we move anything forward, but not really even prepared to spend a lot of time on it because, like I said, I was planning on Title 25 today, but I just wanted to add some of those comments that bringing providers to our state, if we just want to focus on healthcare, it's a monumental lift right now. It's difficult. There's a shortage of staff in every aspect of healthcare, and we can talk about physicians, but nurses are also getting signing bonuses right now that are exorbitant. I've got hospitals offering $10,000 right now as a signing bonus just to bring one on with COVID. And I think COVID has probably exacerbated a difficult situation, but we help put folks through school. We do their training. We help with their insurance. There's a lot of different things we do. And so this isn't just a physician thing. This would be the healthcare workforce. And we're competing against other states to bring these folks in. And so there are ways for folks to move around very easily. And there are other employers that are happy to help cover some of the expenses that may be incurred to get someone out of a contract so that they could compete or if they decide to move their business. So I just think this is a really broad topic that we need to spend more time on before we do anything, at least from the healthcare perspective. And with that, I'd answer any questions.
Thank you, Mr. Boley. Senator Kolb.
Thank you, Madam Chair. Mr. Foley, good morning. So I'm confused. Are you for this or against this?
Well,
Mr. Boley.
Madam Chairman, Senator Kolb, I'm not really in favor of this one. If we're going to move it forward, it needs a lot more work, but I don't think we're in favor of it because there are already provisions in place to help, at least from the provider perspective, the hospital perspective.
So, yeah, I kind of familiar with hospital contracts and cost to hire a doctor and particularly the cost of what the education is for physicians. And then they leave after X amount of time. So I understand that part fairly well. I know there's a lot of costs there, hundreds of thousands of dollars for whatever it costs to educate a physician. So when it comes to the provision about the payback of a bonus, let's say, or, that you can, I guess we consider paying the educational cost of a physician into this lot here. I'm assuming that. that this is in here. Is 2 years better than no years of a, I mean, I realize you're saying, it sounds to me like, and tell me if I'm wrong on these things. Is that what I heard is we need to go further. 2 years is too short. That's what I thought I heard. So I just want some clarification on this because I'm baffled on why doing something is better than doing nothing. And I guess that's my confusion. If you could help me with that, I'd appreciate it. Thank you, Madam Chair.
Mr. Bully?
Madam Chairman, Senator Culp. So if we do anything, it needs to be longer. But I would prefer, and I think that it makes sense to do nothing on this. I think that the market takes care of itself. I think that contracting takes care of itself, at least from the healthcare perspective.
Right.
And we could go back to the bill that was run several years ago. There's a lot of testimony on this particular industry, and we could pull the minutes and everything that was done. I think it was 3 years ago. They all run together right now, but it went through Joint Labor Committee.
It was in the Jonah. Yeah.
Yeah.
18. Representative Washit.
Thank you, Madam Chair. Mr. Boley, how many ballpark figure, how many employees are we talking about in the state of Wyoming in healthcare who have contracts with non-compete clauses? Is this very common in the healthcare industry, or is it the exception rather than the rule?
Madam Chairman, Representative Washit, the last figures I saw, about 40% of providers are employed by hospitals now. And I would venture a guess, not knowing completely, but that most of those have some sort of non-compete or repayment clause in their contract.
Representative Craigo.
Thank you, Madam Chairman. Sort of a follow-up to Representative Washit's question, Mr. Boley. I think we all know what's going on in the world and in the healthcare organizations across the state. And the fact that we do have these non-competes, and we probably have employees of the hospitals that may be quitting. For instance, they don't want to get vaccinated, et cetera. How doesn't that exacerbate the problem of not enough healthcare workers?
Madam Chairman, Representative Craigo, you think I'm trying to understand the question. So you're asking if the non-compete exacerbates the problem?
Madam Chairman. Thank you, Mr. Boley. Yeah, sorry for the poor question. If they have a non-compete and they say, I'm not getting vaccinated, I'm quitting working for you, and now they can't go work at another hospital or another healthcare provider that maybe isn't going to make them get vaccinated, are we going to lose more nurses over the course of the next couple of years? Or other healthcare providers? It could be doctors, it could be any number of people, but nurses in particular.
Madam Chairman, Representative Craigo, to my knowledge, there are no non-compete contracts in place for nurses. Most of them are just for physicians, PAs, nurse practitioners, CRNAs. There are some provisions and contracts for loan repayment if, say, a hospital helps put a nurse through RN school and pays them for 2 years and pays for their education. There are some expectations of repayment, but it's a sliding scale in most cases too, where it's a prorated based on their time of employment. I don't really see it being a big barrier. And with that said, a lot of our nursing staff right now that are leaving employment at the hospitals are going out and they're joining traveling agencies where they're getting paid $200 to $250 an hour as opposed to the regular $30 to $40 an hour. And so the market is actually correcting this and dictating. We're actually in a worse position because of COVID, because we have folks that are leaving full-time employment in our existing facilities to go work for a traveling agency. And then we're competing against other states to try and bring them back at a much higher rate.
Thank you, Mr. Boley. To that point, Representative Stiff, I think you heard that discussion and recognizing that that's a question that will be presented. This bill has an effective date that it is not to, I think, affect on page 9, line 17 through 18, section 2. This act shall not apply. This act shall apply only to contracts entered into on or after July 1st, 2022. So certainly the committee could change that date, but Representative Stith and Mr. Fuller will probably come swing it back to you at some point. But Representative Stith, what are your thoughts? If we were to make that effective immediately and apply to current contracts in place, would that be legal or lawful? Just a soft question there, Representative
Yeah.
Stith.
No, Madam Chairwoman, the reason that it reads the way it does is because that would be unconstitutional to abrogate, for the government to step in and abrogate contractual rights that are in existing contracts, right? We don't, if there is an existing covenant not to compete that has been entered into validly by an employee right now, the legislature doesn't have the power to abrogate that contract. So this is perspective only. I would like to add a comment about the situation with nurses. I think the Supreme Court case of Best Home Health and Hospice LLC versus Jennifer Brown and others illustrates that covenants not to compete are a problem for nurses because they exist. And in that case, the effect of it was 3/4 of the staff of Uinta Home Health, which was the arm of the Uinta Senior Center providing home health services to the elderly. 3/4 of the staff were involuntarily unemployed and had to get out of the area. And it's true that one of the nurses did become a traveling nurse in North Carolina. But but the point here is that good for Wyoming? And I think it's not. So I think covenants not to compete are a problem right now in the healthcare industry. I think hospitals understandably would not want the loss of.
You muted yourself, Representative Stith, or something happened there. We can't hear you.
I apologize, Madam Chairman. I apologize. It's understandable that employers would not be enthusiastic about this bill, right? Because all things being equal, an employer would prefer to have more leverage over the employee rather than less. But if we're thinking about what's good for the community, what's good for the state, what's good for the healthcare sector, and what's good for public health, it seems that we should have a system in place that allows nurses, doctors, physical therapists who want to stay in Wyoming to be able to stay in Wyoming instead of getting effectively chased out of the state through these covenants not to compete. Thank you.
All right, any final questions for Mr. Boley or Representative Stith? We have about 9 minutes to keep working the bill. All right, seeing none. Thank you,
Thank
Mr.
you, Madam
Boley.
Chairman.
Again, Representative Stith, we're going to keep you close. But public comment is closed. So committee, back to you. Any discussion on the bill draft? It's really engaging debate this morning. Senator Kolb.
Thank you, Madam Co-Chair. I was wavering there. The question, is this the right time to bring up changing something on the bill, some proposed amendment? Well, I'd look towards page. Glasses on here.
What we should, so procedurally, someone should move the bill, second the
I
bill.
wish to move the bill.
Okay, is there a second? Seconded by Larson.
So would propose an amendment to the bill.
Okay,
Page 7 in lines 3, strike 2 and insert 3 years of initial hiring. And I propose this with the idea that in some cases, yes, it's too short. In some cases, maybe, it's reasonable with the training and monies, put forth for moving people. And the bonus paid, it seems reasonable that we may start with 3 instead of 2. That's my amendment proposal. Thank you.
is there a second? And Senator Kolb's motion was to change that time year limitation from 2 years to 3 years on page 7, lines 1 through 3. So seconded by Washit. All those in favor of Senator Kolb's amendment to change it from 2 years to 3, please say aye.
Aye.
All those opposed say no. That motion has passed. I'm going to need everyone to vote. So, all right. So for the next votes, everyone please participate a little bit more. I think only 5 of you did. but it did pass. Further discussion on the bill or further amendments? Yeah, Representative Wanitzer.
Thanks, Madam Chairman. I'm not sure who to even ask this to, but I need someone to tell me, I guess, the rationale why the state is going to legislate what, in my mind, is a private contract that a business wants to do. And we just upped it to 3 years. And it fundamentally, I guess, it bothers me that the government is going to mandate private contracts for 3 years. And I just need someone to give me some more justification of why that is in the public interest for us to do that. And I'm not sure I'm there yet. It's my concern.
Yeah. Good discussion. Representatives Wanitzer, further discussion, comments? This is the time for comments, your thoughts on the bill. I share Representatives Wanitzer's concerns. And one thought I had on this topic, this is the first time we've seen a bill draft. This committee meeting is for the committee potentially to continue the conversation at our third meeting. We heard some communications from the Hospital Association that they think the bill needs more work if it passes at all, or if there's continued discussion on it. I am a bit surprised that there is less stakeholder engagement because it does affect a lot of private business in the state. And so a bit surprised that they've not, been more aware of this particular issue. Probably doesn't sound very exciting. And so there's a lack of interest there, but it has profound impacts on their operations. And it also is a fundamental policy shift. My personal perspective is a little bit more in line with Colorado's legislation on that front, which does differentiate between kind of employees who are in a less sophisticated bargaining position with their employer, as opposed to maybe CEOs or the executive staffs or even physicians who are making $250,000 a year and have the ability to easily obtain legal review of any contracts that they're signing for employment and or can easily pivot in the workforce because of their highly specialized skills, as opposed to nurses or other types of kind of traditional skilled labor that we need and appreciate so much. But again, even that goes into the province of evading the freedom to contract, which is a very fundamental policy consideration for the state to consider. So options for the committee is to adopt the bill as amended and take it as a joint judiciary sponsored bill into the 2022 session, or we can see it at our next meeting, or we can dispose of the matter right now. So the motion currently is for Senator Kolb, I think, to sponsor the bill as a joint judiciary bill. So that's the current motion that we're being asked to address. Any further comments with those options in mind, Senator Kolb?
Thank you, Madam Co-Chair. I see this as an equality issue. This is an issue that has broad range between sophisticated and unsophisticated situations with people. I know there's a big problem with folks that hire people on a hiring bonus, and I kind of think of it maybe in the opposite way, that the employee is taking advantage of the employer, and the employer had expectations they were going to keep an employee, and the employee jumped ship, and there's no recourse for the employer after training said employee for X amount of time. And obviously that's the question of how much time I think is reasonable. I think reasonable people can agree that there's an issue here. And I guess the question is what to do about it. I think this is a solution we could work forward and see what we can do. It may not resolve itself immediately with this particular bill. This may have to have ongoing discussion and further bills in the future. But I think letting this go and not having it flushed out and moving forward to know where we can be is a disservice to the people in the state of Wyoming, either employer or employee. So that's why I'm in favor of this bill, that we would pursue this bill and see what we can do. Thank you, Madam Chair.
Representative Washit?
Thank you, Madam Chair. I'm not sure how I'm going to vote on this bill when it comes down to a final vote, but I would like to see it go forward for a third meeting, maybe get greater public participation at that third meeting in Douglas, and we can get some perspective here and then make a decision. So I'm I'm going to support moving the bill forward today. I think it's the right thing to do.
So a couple of things right now procedurally, just so the committee is clear. The motion right now is for the committee to adopt it as a joint judiciary sponsored bill, which means we would not see it at our next meeting. The next time we would address the bill would be in the 2022 session. So if you want to work the bill at the next meeting, you would vote no on sponsoring the bill, but that doesn't mean it's a vote against the bill. It just means you may want to leave the option open to consider at the third meeting. But Mr. Fuller?
Madam Chairman, if that's the course the committee would take, I would just suggest withdrawing the motion and then direct LSO to have the bill for the third meeting.
I could ask the sponsor to withdraw the motion, or we could dispose of it by a vote. Either way is an option for the committee to consider. Senator Kolb, do you want to withdraw the motion, or would you like to have the committee vote on sponsoring the bill?
No, I'll withdraw the motion.
I agree.
And the second agrees, Representative Larson agrees to withdraw the motion. Okay. Would you like to comment too?
I'd
Yeah.
like to make the motion that we bring this up at the next meeting and have more discussion on this.
Second? Seconded by Costa. All those in favor say aye. All right, for kind of direction to Mr. Fuller for that, what I think we should have posted for the agenda is this bill draft as well as the case again, just like we did for this meeting. So it looks very similar. And I would make a motion for a bill draft, which is kind of unusual for the chair, but I think it's important for purposes of the discussion, that adopts Colorado's legislation. And seconded by the co-chair. And I'm not advancing that again, but I just think it's helpful to be able to see that and compare and contrast the different options for the committee. So all those in favor of my motion? Yes, Co-Chairman Olson?
Thank you, Co-Chairman. I just wanted to speak to that because I'm listening to Senator Kolb, and Senator Kolb brings up what Representative Stiff highlighted as the policy consideration on why we even are considering this legislation, which is simply the concept of unequal bargaining power. But what I heard from Mr. Boley was that he said about 40% of providers would have a contract like this in Wyoming. And that stuck out to me because he's talking about physicians. And I think, Senator Nethercott's spot on with the issue is on the lower end of our spectrum that we're concerned with that may not be in the higher percentage of those contracts. But if they are, I think that I don't know anything about the Colorado version, but if there's some way to separate out those who truly enter into the bargain unequally, i.e. the nurses, surgical techs, whatever that may be, I think that's a good way to approach it. So I'm interested in that idea. And I think that gets to what you're really searching for, Senator Kolb.
Any further discussion on my motion? Seeing none, all those in favor, please say aye. Everyone vote. All those say no? We're going to do it one more time. All those in favor of directing LSO to do a bill draft to adopt the Colorado legislation concerning covenant nots to compete, please say aye.
Aye.
All those opposed say no. That motion has passed. All right. And committee, I know it's a little bit early for a break, but it is the morning, and I think earlier breaks are better than later breaks. And we're about to go into the big topic of Title 25, which will devote all of the rest of our morning to that. So let's go ahead and take a quick about 8-minute break here and come back at 9:40, and then we'll work that topic, Title 25, until we break for lunch. So quick break, committee. Thank you for your efforts this morning. All right, committee, thanks for coming back from the break. We'll buckle up here as we head into Title 25, a big topic for our morning on the second day. I know we have with us a number of folks from the County Attorneys Association that worked on this topic. If you recall from our last meeting, the committee gave kind of instruction to them to take liberty to do a Title 25 rewrite based on what they thought would be best practices. And so if you look at our agenda items and the meeting materials, where we're going to go is to tab 701, the Title 25 rewrite final version. And it's my understanding that the county attorneys worked on their Title 25 rewrite. We kind of pushed them to make sure we could get the materials ahead of our meeting and then published and turned it into an LSO bill draft. After we did that, then they, I think, obtained consensus from more of their members and did a final version of the rewrite. So what we're going to do is start with that final version of the rewrite, which is not an LSO bill draft form, and hear from kind of the prime laborer on that topic, which is Ms. Charmaine Reed from the Natrona County Attorney's Office, who I think did most of the heavy lifting in consultation with other county attorneys across the state to walk us through that final version of the bill. Then what we'll do is we'll hear from Mr. Fuller and talk about the differences between maybe that final version and what LSO has prepared, discuss those comments, and then go to further public comment from there. So Ms. Reed, welcome back to the committee. It's great to see you here in Cheyenne. You'd introduce yourself formally to us and then walk us through this final version.
Okay. All right, I'm Charmaine Reed, Deputy County Attorney for Natrona County. And I've been working with several other deputy county attorneys, one from Sheridan, one from Fremont County since 2018. And we finally got what we think is not necessarily perfect, but complete to work with. It's unfortunate we couldn't get it to the LSO in time, so we just have one document, but I appreciate being able to go off of what we have finally. And I can't tell, is Mr. Beaver on?
Yeah, Madam Chairman, they just need to turn on their cameras.
Yes, Mr. Beaver and anyone else. I think that's all that's appearing on Zoom. Mr. Beaver, if you would turn on your camera so we can see you, and it'll be like you're appearing here together with Ms. Reed.
Okay, and if the committee doesn't object, we'll kind of tag team-ish our presentation.
Sounds good.
So just starting really basically, I'm not sure how many people have any familiarity with Title 25, which is what it's referred to. It's Title 2510, 2510-101 at SEC, and it's for involuntary hospitalizations of people with a mental illness that is creating some type of problem, either for the person himself or someone else. And so the way the process starts out is that a person with, I'm just going to call it a serious mental illness, just so it's more than a mental illness. It's something that the government needs to be concerned about. So when someone with a mental illness is identified either by a family member or in interaction with law enforcement, a peace officer can place that person into emergency custody. And then they would transport the person to a facility of some sort. Also, an examiner, as defined in the bill, could place somebody in emergency custody. So that's the first step, is someone is identified as having a serious mental illness, and either a peace officer or an examiner may place that person in emergency custody. The person's then taken to a facility We said facility as opposed to treatment facility because some counties don't have a treatment facility and they have to keep the person somewhere. So mostly it's the most appropriate facility available. We include that it should not be a jail type facility unless there's extreme circumstances and there's no other safe place to keep the person. The person with a mental illness can be kept in emergency custody. Well, okay, so first, once somebody's placed in emergency custody, they have to be examined within 24 hours. And that means somebody with some knowledge of mental illness has to look at the person and say, yes, it appears this person has a serious mental illness and should be kept in custody for up to 72 hours from the initial placement. So far we have the person placed in emergency custody, a 24-hour exam, which is somewhat cursory, but it's to give that due process that yes, someone thinks this person has mental illness. And that can be for up to 72 hours. If they want to keep the person longer, prior to the expiration of the 72 hours, there has to be a hearing. And the hearing would be in front of district court or in in many circumstances, a district court commissioner. And at that hearing, the court would determine whether the person has a serious mental illness and if the person should remain in emergency custody. If emergency custody is continued, that can last for up to 21 days. And we did that for several reasons. The current process is 10 days. Somebody can be kept for up to 10 days. But there's a lot of situations where somebody is like nearly stabilized at 9 days. And we end up having hearings where we have a hearing, person's ordered to stay a little longer and the next day they're released. And so we thought the 21 days is reasonable due process because the patient's been seen at 24 hours, at 72 hours, and then held for up to 21 days. During those 21 days, an examiner has to be submitting reports, evaluations on the patient. So even then, the patient isn't just locked away and forgotten about. There's supposed to be weekly evaluations to help track the patient's progress. And the way the statute's written is at any time during those 21 days, either party could file a motion for a hearing sooner. So if it was obvious this person needed to go to the Wyoming State Hospital to be involuntarily hospitalized, either party could request a hearing to have that considered by the court sooner. And on the opposite end, if if the patient's attorney thought that the person should be released, that the person no longer had a serious mental illness, the patient's attorney could request a hearing and the court could consider that. What we're trying to do is make sure that throughout the process, the patient has appropriate due process. Because the government has an interest in protecting people, the patient himself and others, they're allowed to get involved. At the same time, this person hasn't done anything wrong. The person just has an illness. So what we're trying to do is the least restrictive placement including actual placement and duration, that protects the patient and the public. So after, let's say nothing happens, 21 days runs, if nothing is filed, the patient would be released at the end of 21 days. If the parties want to continue either emergency custody or move to involuntary hospitalization or switch down to what we're calling directed outpatient treatment, which in the current statute is referred to as directed outpatient commitment. There could be a hearing on that. And one of the things about what we've proposed is that those three stages are a continuum. And so at nearly any hearing, the court can consider the evidence and place the patient in the most appropriate available option at that time. One of the things we talk a lot about is the best available option. And that has to do with different counties having different resources and mostly doing the best they can with what they have. So another thing we've done is, so we have the three different types of Title 25 involvement. If somebody's in directed outpatient treatment, they are not in state's custody. If they're in either of the two, it specifically says they are. The current statutes don't say who's responsible. I mean, everyone presumes it's the state, but it's not spelled out. So we've spelled out if somebody is in emergency custody, if someone's involuntarily hospitalized, they are in the state's custody.
Ms. Reed, I went flipping through my bill draft here quickly. Can you help the committee understand what you're looking at right now, where you are?
So I'm generally in 25-10-603 under process.
Thank you.
And so what we did was try and put the process for everything in one spot instead of thinking, okay, this is continued emergency custody. We need to look at the rules for it, or it's involuntary hospitalization. There's different rules. We try to make the rules the same, whatever the parties are trying to accomplish. So if a party wants to file a motion for a hearing, the party is required to attach an evaluation report. And that, well, provides the best snapshot of the patient's condition at that time. It has to be an evaluation that was done within the last 3 days. And so we have that in there. Also, in just the general process, we have what happens if an examiner finds that a patient no longer has the requirements of a serious mental illness. And the process includes an opportunity for each party to object. And so each of our little steps they stem from a problem we've had generally. And so what we've had, some attorneys have felt like patients were released before it was appropriate or before there was a discharge plan that was going to have any chance of success. being in place. And so by doing this, we're involving both parties' opportunity to object and also involve the treatment coordinator, which is, we have the treatment coordinator greatly involved with everything, tracking the patient's condition, success, how they're following the treatment plan. One of the, I'm going to jump to directed outpatient treatment. And
What
that's
page is that? Page 20, okay.
And so this is the section that we're really hoping could help both the county, the state, and the patient. And it's largely directed at patients who need some sort, who don't need to be in custody. They can be out in the community, but they need some sort of structure to successfully continue medication, which if they didn't take, they would deteriorate and then end up back in emergency custody. So we're trying to have an enforceable plan to help people stay on their meds is what we're trying to do. And there's a treatment plan. The treatment coordinator is the one that's monitoring whether or not the patient is following the treatment plan. The reason why this proposal has a chance of success is the definition of mental illness that we have, which is back towards the front on page 5. And so we define mental illness on purpose to say, here's mental illness and it's not a dangerous thing. And then we define what the purpose of this proposal is about, and that's a serious mental illness. And so that's when the government needs to get involved. And largely it's subsection 3 and subsection 4 that the directed outpatient commitment would work with. And so other jurisdictions have done this where they have people who are on a court order who must follow a treatment plan to help keep them on their meds, to help them take care of themselves so they don't end up back in the system. And so I shot you to page, it's page 5, 6, but back on emergency custody, the key that the county attorneys need was some way to enforce it because, well, I'll just go with this. If on page 20, if an examiner determines that the patient has not complied with the patient's directed outpatient treatment, the examiner may place the person back in emergency custody. So kind of going to that starting point, it's still one case, but we tried to keep the person stable on the outside. And if it doesn't work, then the person goes back into emergency custody. So still on the continuum, just going up and down the continuum. The biggest thing here is that this provision allows enforcement when somebody doesn't follow the treatment plan. Right now, if somebody is out on directed outpatient commitment and they're not following their treatment plan, most of the county attorneys don't think we can do much because of the definition of mental illness. Because if some person who hasn't committed a crime is just some person chooses not to follow a treatment plan, but hasn't quite reached the level of a serious mental illness, we have no right to do anything to them. We just have to wait till they destabilize completely and then put them back in the system, which is bad for the patient to have to get that severely ill in order to get help. And well, is also that much more dangerous to the community. So when I've had somebody out on directed outpatient commitment who isn't following their treatment plan, what I do is write a letter on my letterhead saying, oh, here's letterhead, please start doing what you're supposed to. And if they don't, then we dismiss the case. Because if the person doesn't qualify as seriously mentally ill, Title 25 doesn't apply. And so by adding to the definition and adding the enforcement provision, we have authority. So if somebody is out there not following a treatment plan, it's not an impotent threat. We can say, please follow this treatment plan or you're going to be back in custody where you don't want to be. Sometimes it'll work, sometimes it won't, but at least it gives us some enforcement option. So those two things. So we like the continuum. We don't want somebody to have, like I had one hearing, it was an involuntary hospitalization hearing, and had the hearing, the district court commissioner found that the person, his illness did not rise to the level of mentally ill by clear and convincing evidence, which was the burden for involuntary hospitalization. He said it met the requirement for emergency detention, but since it was an involuntary hospitalization hearing, he let him loose. And that's just kind of nonsensical. And that's why we want the continuum. We don't want to have to, say this is such and such a hearing and we must meet this burden or the case is dismissed. So we like the continuum. And then the change in the definition of mental illness and the enforcement of directed outpatient treatment are key to the changes that this proposal has. And so that's within the process section. It's really within, what are we calling it, Article 7? No, we're calling it Article 6. And so that's the substantive part of the process that we want for the patients. We intentionally put the definitions in with the process section because they're connected. Clearly, if the definition of mental illness changes much, that could affect what we can do with them, that they may or may not fit for the directed outpatient treatment. There's a couple more things, and then I'll let Mr. Beaver maybe more smoothly discuss more. One is the way we have the definition of mental illness. We want it clear. So what we have in the proposal, it does not broaden what the definition is now. It does not broaden anything. It specifically lists dementia, it specifically lists traumatic brain injury, but both of those are a physical thing affecting the person's conduct, which is included in the current definition. So when people get concerned about it being broadened, it's not being broadened. So, but that said, the way it's designed is you can shuffle it. If you want to broaden it, you just, start putting in the conditions you want under this definitely includes. And conversely, if you want to exclude dementia, you just move it down. So we clearly know what's covered. And again, that was kind of the impetus for all of this, is just being frustrated and wanting clarity. So if you want to include dementia, yay, leave it where it is. If you don't, move it down, we understand. The same thing for other types of mental illness. So that's one thing is we don't want to tell you what to include, exclude. We can, tell you anecdotal experiences that we've had. It seems reasonable that the medical and treatment people would weigh in on what was appropriate. I know some county attorneys, their practice is not to include dementia. They're concerned that if dementia is included, that's where the broadening is. So this just helps everyone out, just makes it clear. One of the other things, and let's see if I can find it in here. I'm not finding it right off the bat. I'll look for it while Mr. Beaver's talking in a minute. But one of the things that is, I think is critical in this proposal is that people are permitted to voluntarily get help. And if I've had situations where where a patient is unconscious and then placed in emergency detention. And my position is that person is not a current danger to himself or others because he's unconscious. Maybe when he becomes conscious, he is. And at that time, maybe emergency detention is appropriate. But a patient who is unconscious should not be placed in emergency detention, emergency custody. And sometimes a person is at the hospital and not medically stable. And I think even if the person's medically unstable because the person hurt himself, if he doesn't want to leave the hospital because he's there getting medical treatment, there's no reason to put him on a Title 25 hold. So this proposal has provisions that mostly prohibit doing that. If a person will willingly stay, voluntarily stay, please don't place them on a Title 25 hold. That will help us all out. Another part of that is if somebody comes in and wants help and says, I'm feeling suicidal, I would like to see someone. I think most of the time where I see it when somebody's placed on a hold, but the person drove themselves to the hospital, said, hey, I need some help. And then the examiner put him on a hold. And this proposal prohibits that. I mean, somebody can come in and get help without the fear of being put on a hold. So over the 3 years we've been working on this, we've talked to a lot of different people. One of the things we heard from law enforcement quite a bit was they didn't like transporting non-criminals. And so we've addressed that in here, that law enforcement, I don't know if we say peace officers specifically may transport somebody who's placed on a hold in the same manner that they transport others. So in a reasonable manner. Also in here is that if whatever entity that is allowed is transporting a patient in a reasonable manner, that entity cannot be held liable for that. Because those were the two concerns we heard from law enforcement was who says we have the right to do that? And do we get to put them in handcuffs, or how do we do that? And so we wanted to spell it out exactly that, yes, they may, we need them to. The flip side is they don't want to. They would like to say, some of them probably like to say, no, they may not ever do it, find somebody else. But as it stands, they specifically can and should not be held liable. I'm going to keep flipping through, but turn it over. Mr. Beaver, would you like to comment on anything I've said or move on to the rules and fees?
Mr. Beaver?
Yeah, thank you, Madam Chairman. I'll hit a couple things that Charmaine didn't get to. First, she made reference to rules, and we've provided would be on page 21, section 701, subsection D. The legislation would direct the Department of Health to adopt rules and regulations in accordance with the APA within 180 days of the effectiveness of the act. And the subject matters that would be set forth in those rules, first of all, would include the parameters for a medication review committee. This comes out of concerns as to whether hospitals are authorized to administer certain medications to a particular patient. I know that the judges are not at all comfortable sitting in judgment of questions of prescribed medications. In fact, that should be in the realm of the medical professionals. So that's why it's being addressed that way. And the next subject matter is to dealing with payment, cost invoicing from the providers, rules as to how that should work. And then, as Charmaine made reference to, rules that address transportation issues. And the reason that we put these subject matters in the hands of rulemaking as opposed to being embodied in statute is these are things that we sense are, there needs to be more flexibility. The landscape could change in a way that it would not be efficient to have to go back to the legislature to address these. With the APA rulemaking, all the stakeholders and the public have the opportunity to provide input and help mold what's going to be a reasonable and workable regulation on those subject matters. The other item that I would touch on, Charmaine made reference to a treatment coordinator. Now that's a new term for an existing position. In 2016, the legislature adopted amendments that created a position of gatekeeper and assigned some responsibilities to the gatekeepers. That particular nomenclature is somewhat problematic. What we've stolen from other jurisdictions is the term treatment coordinator, because what we're really looking for here is a position that can coordinate between facilities, between these levels of care, and even coordination between counties, because it's not unusual, given the lack of resources in many counties. The patient is brought into emergency custody in one county and then transferred in short order to a county that has a facility, an inpatient psych facility primarily. And so then you're dealing with resources in two different counties. when that patient is discharged with a discharge treatment plan from the treating county back to the county of residence. We believe it'd be very helpful for that treatment coordinator to be involved in keeping track of that patient, making sure that they get the follow-up that's appropriate. So new term, treatment coordinator. It's an existing position. We have clarified, we've now lived with the position for 5 years and just cleaned up some of the language and assignment of responsibilities based on what we've learned in the last 5 years of what we might reasonably expect from treatment coordinators. Again, those are designated by the Department of Health. So they're plugged in at the state level to the department through that designation. Those are the two things that I wanted to be sure to weigh in on. Thank you.
Thank you, Mr. Beaver. And I think we failed to properly introduce you. So if you could just state your name and who you're with, just for purposes of the record here.
Thank you. Clint Beaver, Deputy County Attorney in Sheridan County.
All right. Thank you, Mr. Beaver. All right. I know there's some frustration, I think, from the committee members regarding the physical copy that was maybe mailed out in your packets or is available. That it doesn't have page numbers. Wasn't aware of that. The link on online does have page numbers of the rewrite version. So maybe we can get you some page numbers to help you through that from what's printed online to help with some of those frustrations from the committee members. Or if you have a page numbered version, if you'd share with a colleague so they can help follow along would be helpful too. So apologize for that. Maybe some further background, Ms. Reed, Mr. Beaver. I know from our last meeting kind of gave you the full go ahead to do a rewrite. I know you pushed it out to the County Attorneys Association. Can you give us a sense of some of the feedback? Is there strong consensus, moderate consensus, no feedback? I know wrangling your bunch is difficult, a bit like herding cats at times as a result of how busy you all are. So understand those concerns, but if you'd share with us maybe your understanding of the level of feedback you received.
Right. And I don't mean to be flippant, but the answer to your compound question is yes. So there is there's some support, some strong support. There's some strong dislike of it. There's comments that this isn't any better, comments that this is worse. One of the things that this proposal does is have the county attorney's office keep the case for the duration of the case. Currently, what happens once a patient is officially involuntarily hospitalized, the county attorneys have no authority to do anything with the case. So it's just out of our hands at that point. The Attorney General's office, I guess, kind of takes over. It's just a coincidence. I'd always thought that didn't seem quite right, but within the last year, I had an experience that kind of showcased one reason why it's problematic, and that is I had a patient that had been ordered to involuntary hospitalization. And so we've got a court order that says go to the state hospital, and the state hospital through its attorney, the Attorney General's office said, no, we don't want it. And I didn't have any authority to say, yeah, but it says. And so it's not really reasonable to have the Attorney General's office supposed to be representing their client, the Wyoming State Hospital, while also continuing to say prosecute, but as a legal term to move that case forward. Those roles, not always, but sometimes can be in conflict, as was demonstrated. It worked out. They found places and everything was fine for this instance. but I didn't have authority to say you need to follow the court order. And so this way, the county attorneys just keep it. That's something that the county attorneys don't love. I mean, they don't want more work. I think some of them understand and appreciate that that's better, that there's 2 Park County cases trying to hammer out what exactly a county attorney is supposed to do with regards to involuntary hospitalizations. And this spells it out. You know, the county attorney gets it from the beginning to the end. And I was going somewhere, but I don't know where the "and" was going. So it's clear. We also have under the responsibility sections, the what county attorneys are required to do. It what I was going to say was I did hear a few comments that were in support of keeping the county attorney's authority. So some didn't want the extra work. Some appreciated that with the authority, it would be helpful. The county attorney responsibilities that are spelled out give the county attorney discretion still to evaluate the case. So we don't have to file a case for whatever comes in. We still have the responsibility to look through the evaluation and see if the elements are there. So nothing changes with regards to that. The county attorney is still the one deciding if a case begins. So some other comments that we heard were just that the different counties have different resources. And I mentioned the one about treatment facility. Ideally, we'd like to have people who we pick up because they're ill go to a treatment facility where they can get help. But in some instances, the person's held at a place to keep them safe, but they aren't receiving any treatment, you know, for months, maybe waiting to get transported to an open bed in a treatment facility. So our language tried to work with that to not make it unduly burdensome for the smaller counties with that issue. Mr. Beaver, do you remember other issues?
Well, to address the chairman's question, we probably had a half a dozen very detailed reviews of the bill and making good suggestions. Those have been incorporated. That's why the drafts were kind of a work in progress as those comments came in and were incorporated. Our president of our association, John Worrell from Washtenaw County, sent us a message last week, and after having polled the full membership and represented that we could tell you there's general support for the bill.
Which is pretty remarkable for attorneys, right? And in many cases, elected attorneys as well. Right? So Representative Oakley.
Thank you, Madam Chair. And thank you.
Charmaine.
Thank you, Charmaine. Yeah, it was your last name. Miss Reed, thank you. So when you were having this discussion, was there a discussion, I've seen it before, about the costs associated with emergency detention being shifted to the Department of Health? Because I hear repeatedly, and I think it is a concern for smaller counties, you mentioned it, as far as specific resources. And if it were, if it were under the umbrella of the Department of Health, the state could then leverage, and have contracts and even that out. Clearly county attorneys are still going to be doing the work, handling the case. Doesn't it make sense that we could shift this to the Department of Health, and was that discussed?
Thank you. Well, generally that's their fantasy. So we, they, for the reason you said, they would like the Department of Health, the state to cover the costs. There are legitimate reasons such as leveraging the ability to get lower prices. And because of the population of the seriously mentally ill folks, sometimes they're transient, sometimes it's not clear what county they're in. So pretending we can identify their residents, their county of residence is frustrating. I mean, and it's not necessarily clear.
Thank you, Madam Chair. So, so again, that would point towards, that wouldn't be an issue if it were under a state umbrella, right?
Yes, that would help greatly.
Thank you, Co-Chairman. Ms. Reed, I just want to follow up on that. So we have just a summary of if there was a change versus what we had in place, just the 10,000 foot viewpoint, which is, if I understand this right, non-residents, State of Wyoming Department of Health covers, residents of the state of Wyoming covered by the county where the involuntary commitment or hospitalization takes place. You're speaking to that's the existing law, right? Let's start there.
Kind of. So the county, and I think the statute says of residents or where the person or where the person's picked up. And so I'm sure the counties are fighting over who gets that, but the county pays the cost for the first 72 hours.
Okay,
And then the state takes over after that.
perfect. Okay. And then so where have we made a change to that right now, or we don't have a consensus on that because there's a fantasy about what we want versus what other stakeholders might want?
Well, what the county attorneys would like, and they didn't vote on this specific issue, but what I heard strongly is they want out of the payment business. You know, they'll do the work, but trying to figure out, you know, costs, who's getting billed more. It doesn't seem reasonable that Washakie County would pay X amount when Niobrara is paying Y. And we want it consistent and really, we think it's really reasonable for the state to pay given all of the circumstances, including that the treatment facilities aren't everywhere. It's not, you know, evenly distributed for the counties to figure it out for themselves. The state has the ability to look at everything and identify who is going to place these people, including the aggressive patients, which also creates a big issue. So the state is in a better position to say, okay, if you want our money for regular patients, you need to take these aggressive ones also. Because right now, I'd say probably close to all of the counties struggle with what to do with, you know, a schizophrenic person who is attacking staff and other patients.
Madam Chairman, then, so just in the draft as a starting point, do we have a decision on where our starting point is? I understand your association's position.
Madam Chair. The draft that we have does not have that fantasy position. It has a compromise based on kind of what we were feeling, that we weren't going to get what we wanted. We weren't going to get that super goal. So one of the county attorneys suggested really kind of at the last minute, okay, fine, let's just make it equivalent to Medicaid rates. And so still the county of residents is paying for the first 72 hours of the initial emergency custody. So we're trying to reduce the number of initial emergency custodies. So we're trying to reduce our costs that way. We're also in the draft asking the state to pay for transients. So that's our compromise that we have in there right now.
Ms. Reed, I know that Medicaid reimbursement provision has created a lot of angst. So whoever that county attorney is, you should name them.
No.
So those frustrations are appropriately vetted there. Senator Kolb and then French.
Thank you, Madam Co-Chair. Could you expound a bit about the first 72 hours? Because my understanding is that's not, exactly accurate because it excludes weekends and holidays, which I think anybody that knows about Title 25 knows a lot of folks come in on the weekends and holidays.
Mhm.
So it was a huge cost to the counties beyond. If it was 72 hours, I think that'd be a great change. I don't disagree with 72 hours, but I think there's a lot of cost involved. I just wanted to help maybe other folks. If you agree, is that true?
That, Madam Chair, that is accurate. The way it's calculated is 72 hours, weekends and holidays don't count. And inevitably somebody gets placed on a Friday before Labor Day, and they get to stay until Wednesday, the following Wednesday. We kept that method of counting in the proposal, not because we like it necessarily, but kind of as a compromise. I mean, we have these ideas, we're kind of given direction, but don't go crazy cost shifting. So it's like, okay, well, we'll keep 72 hours. And so that's what we have. Other jurisdictions use 48 hours as the time before a hearing has to be held. Initially, I liked that idea. Our feedback was that was not going to work at all just because of the short time to have a hearing in 48 hours, that wasn't workable. So they didn't want to reduce that. So we kept 72, kept weekends and holidays don't count. We clarified that after a weekend or holiday, it does start counting at 8 a.m. the next business day, because we didn't even have that, or we don't have that in the current one.
Senator French.
Thank you, Madam Chair, Co-Chair. I have pretty much the same comment as Senator Kolb. The county, I mean, if it was 72 hours, it'd be so much better, but rarely is it 72 hours. That's only if a hold's placed on a person on a Monday, Tuesday, or a Wednesday, is it 72 hours. The Thursday and there's a holiday on a Monday or a Friday, it's up to 6 days, double. And that's generally you've got, the counties have a 5-day cost, not a 3-day cost, because those holds maybe they're working and they go home on a Friday or they drink or whatever triggers their mental health episode. So, then it's through the weekend. So that's huge cost to the county. And another part of that is trying to recoup the costs, the county, sometimes the hospitals, if they were, put in the local hospital for a little bit and had somebody sitting there watching, observing them, there was all kinds of things added in those bills. It was just unbelievable. versus just somebody sitting there to watch them, or the bed for the night or the day, that cost from the hospital. There's all kinds of stuff added in. So I hate to say this because I dealt with it for 18 years as a county commissioner, and Senator Kolb for a number of years, at least 8. It's really expensive to the county, and this program is a giant mess. One other comment, if I may, is the state hospital, if they are need to go to the state hospital, is the state hospital, because I saw somewhere in there that this bill would develop a plan to manage when the timeline that they might be admitted down there. Can the state hospital currently, do they have the beds to admit the people that are sent to the state hospital?
Right, sure. No. So that's one of our big frustrations is a person will be placed in involuntary hospitalization and just stay where they are for months because the state hospital doesn't have room for them. And so just trying to understand things better. That's why we're that's why this proposal requires rules and explanations about how the state hospital is handling its backlog. Just transparently, why can't we get a bed? And also, this proposal states that if the state hospital doesn't have a bed, that it's responsible for finding something equivalent for the patient who's been placed in involuntary hospitalization.
Thank you, Madam Co-Chair. If a person has an episode, they need help, are these other, if they can't get into a bed at the state hospital, they obviously need some help if they're sent, further help if they're sent to the state hospital.
Mm-hmm.
Are these other facilities that you talk about that you try to find a place for, do they have the training and the ability to offer what the state hospital staff does?
I don't know. That would be a question for the Department of Health to figure out which facilities have what, to know kind of what the inventory of options is. I don't know. I'm in Natrona County. WBI takes our people after they've been at the Wyoming Medical Center and then generally keeps them even if they're involuntarily hospitalized, they'll stay at WBI until they're stable enough to be released. I'd say, I don't know if it's rarely, but close to rarely actually go to the state hospital.
Ms. Reed or Mr. Beaver? Senator Cost?
Thank you, Madam Chair. Thank you, Ms. Reed, for all this work you've been doing. The 72 hours, the other option would be to say, okay, we put it on 72 hours, no matter whether there's holidays or whatever. But I have a feeling that the attorneys are not going to be appreciative of that either, correct?
Yeah, that'd be a downside.
All right, further questions? All right, seeing none, Ms. Reed, stay close by. And now and Mr. Beaver, please stay online and with your camera on too. I just think that'll be helpful for now, and so we can easily get to you if we need to have you answer some questions. So with that, we'll, I think, go to the Hospital Association, who I know is here to speak about this bill we heard before. And is the AG's office intending to provide some comments as well? No? AG's office, no? Okay. All right. Mr. Boley, you ready to come forward?
Madam Chairman, Chairman Olson, committee members, Eric Boley with Wyoming Hospital Association. And obviously Title 25 is an important issue for hospitals around the state. And more importantly, it's an important issue for patients that need help. This process started out more than a year ago. It was a collaborative process. We were working closely with the county attorneys on this. And I hadn't seen a draft of this bill until Thursday of last week, but at some point,
Mr. Boley,
yes.
I'm just going to provide some procedural correction to that. Title 25 was a topic for the Joint Judiciary Committee in the last year. There was a working group that was created, which was comprised of all the stakeholders. They produced nothing for the committee to consider in a meaningful way. And so that issue was dropped for the interim and we didn't proceed forward. And I understood that there was kind of a stall amongst the stakeholders and no product could be produced as a result of kind of the friction that was created. And so at our last Joint Judiciary Committee meeting, recognizing this was a topic still to commit to consider, wanted to hear from the county attorneys about the judicial process associated with Title 25s. The direction from the committee and was to limit the scope of any rewrite or changes to really the legal processes associated with involuntary hospitalizations. Really wanted to stay out of the nightmare of costs and reimbursement, which the Health and Labor Committee has done before, and which is an area of there will never be consensus or agreement on. So really, the Joint Judiciary's role was an understanding of what that legal process intakes look like, the due process associated with somebody who's involuntarily hospitalized. And invariably, we're not ever able to kind of understand those details, and it turns into compensation. And I don't want to minimize the significance of that, because clearly that's what everyone wants to discuss, is compensation either from the counties, from the state, transportation costs, location, which county, which treatment coordinator. And we get in this dispute over who should pay, as opposed to reviewing the legal processes associated with it. So to get some type of work product for the committee to consider from the county attorneys who work in the space, ask them to just go ahead and provide what they wanted. We received it when we received it. They did go outside the scope of what I think, asked them to do, which was they did touch on that compensation piece, which has triggered Mr. Boley to be here today and be as frustrated as he is, and putting the committee in this situation of, again, trying to navigate these compensation costs, which I had hoped to avoid for years, and which stalls the conversation out and we can never get progress. So that's kind of the procedural, I think, candid history associated with the topic. But we'll deal with it now and understand those compensation pieces, and look forward to hearing your concerns about compensation losses. Thank you, Mr. Boley.
And thank you, Madam Chairman. But to be fair, we actually continued. I have been continued to work with both Mr. Reed and Mr. Beaver through this process since the interim. And so I was a little bit caught off guard by this. So with that said, WBI is probably the biggest player in this as far as hospitals are concerned, separate from the state hospital. Been a lot of good questions about access to care. There's a lot going on right now, and I think Stefan Johansson, Director Johansson, is available to talk about some of the work that's been done. But state hospitals undergone a major renovation. Life Resource Center in Lander is now undergoing renovation so that patients that have been in the state hospital for a long period of time can be transferred to Lander, creating more access to care or more beds available in Evanston. But the one thing to realize is that we're, like we talked about earlier, in the other bill, is there's a staffing shortage. And so the ability to staff all those beds may become an issue for years to come. Currently today, WBI has 45 state patients in their beds. And so they're carrying a tremendous amount of the burden, which they're happy to do in caring for these patients. And so I've kind of walked through the draft bill with WBI, who this would impact more than anyone, although this will impact all designated hospitals. And there are just a few areas before we get into the financial side that they wanted me to bring forward. Transportation on page 14 is, and I'm not going to get into the cost of those right now, but it's an issue. when a patient is discharged or otherwise released from being subject to this act, the facility holding the patient must make arrangements to transport the patient back to the patient's residence, or if the patient is transient, to the community where the patient was placed in emergency detention. Some of the concerns, WBI and the other hospitals don't operate a transportation or transport service. Some patients are transported by the Wyoming State Hospital. There is a transport available, I think it's one, and we can access it when it's available, but that's one to cover the entire state. Some patients make arrangements for their own transportation. They're picked up by family members or friends. There are times, particularly right now during COVID, preventing the state hospital transport when WBI arranges for taxis, bus, or air transportation to return patients to counties or states. Some patients do not go back to the county of detention because they transfer to group homes, nursing homes, or other facilities for continued treatment, including Central Wyoming Counseling and Volunteers of America substance abuse treatment facilities. And some patients may need or want to return to the county of detention, and the community may not want the transient individual returned to them. So on page 14, there are some issues that arise from the new draft statute. On page 22 and 23, it talks about under Romanet 3 set for the process to transport patients. The process must include, at a minimum, the entities in addition to peace officers that transport patients, the manner in which patients may be transported, including the use of restraints and transportation to and from facilities and public-private places as necessary to carry out this act. Obviously, patient safety during transport is a concern, but it's not clear whether this section applies to the transportation section on page 14. If it does, options for transportation back to the communities may be limited because of these provisions on 22 and 23. Also on page 23, under EF, the department must clearly post on its webpage a current list of all the treatment facilities with which the department has contracts will accept placement of patients. And posting the availability of locations for referral of patients does not guarantee patients will be admitted to those locations because there may not be readily available beds. Page 25, treatment facility responsibilities. Each treatment facility must admit, this is under admit voluntary admittees for treatment. If a treatment facility does not have a bed available for a voluntary admittee, the treatment facility must refer the voluntary admittee to other available treatment options. A treatment facility must not place a voluntary admittee in emergency custody. We talked about some of the access to care and the fact that there may not be beds available. And some of the issues that we're facing is that even trying to transfer those patients out of state, we're having difficulty in getting them there. And so some of our concern is unlikely there are going to be other available reasonable treatment options in many places in the state. Some people may be unable to find and get care. Since the treatment facility must refer the voluntary admittee, what if they can't or don't? And some individuals seek care and then change their minds after indicating they are suicidal with plans or presenting as psychotic. And voluntary admitting may have to be placed in emergency custody for their safety if they're at risk of harming themselves or others after leaving treatment. So those are concerns on that one. I just have a couple more. Court process, page 19. Finds by clear and convincing evidence that the patient has a serious mental illness and voluntary hospitalization is the least restrictive placement available. The court may order that the patient be placed in voluntary hospitalization. The concern is that psychiatrists are very difficult to recruit. We're in a huge shortage in our state. We're trying to fix that. But as of right now, the shortage exists. So not all treatment facilities will always have a licensed physician available to testify. Campbell County Health or Behavioral Health, Ivanson Memorial, WBI are examples of some that do at times, but at all times in a licensed, they don't have them at all times. And a licensed clinical social worker or psychiatric nurse practitioner may need to appear in court instead. Some counties don't want a licensed physician to testify Laramie County is one that doesn't want a licensed physician. So it's all over the board right now. So one of our hopes as we went through this was to create consistency across the county so that no matter which county you're in, it was dealt the same. So this one creates some concerns for us because it's still all over the board on what would be the right type of person to testify in those hearings or the availability for them. Before I get into reimbursement, I'm getting all kinds of information here. There's some concern.
Mr. Boley, on that topic.
Yeah.
There's two concepts that I think that come to mind. I just want to plant the seed on this piece, which is who can provide appropriate testimony to the court. So this is a legal question, which comes into the type of admissible evidence and expert testimony. And then secondarily, we can put into statute what the court is to consider. And so it is the custom to have potentially a psychiatric nurse practitioner when there is not a licensed physician. What does the medical community say? Who is qualified medically to make that type of determination or diagnosis, I guess? So what do the practitioners say? What does the medical community say? Who's qualified?
Madam Chairman, I think that's a really good question. And I think that
Not the optometrists.
no, nor the ophthalmologists, or I'll list them. I think there are trained personnel. I think they have scope of practice. I think the Department of Health could probably help us with a qualified list of people that could testify. But the reality is in each community, it's probably going to be somebody different just because of they would have to have that expertise, but it's not always going to be the same specialty or the same high level of licensure. And so I think that might be something that the Department of Health could help us with. There's a concern by some of the providers that there's a felony attached. Let me see. You know what that one is? Yeah. In the front. On page 4, under statute, under section 2510-504, there's always concern about the potential for a felony and so just wanted to bring that to your attention. I'm receiving feedback as we're sitting here that there's concern over that. And I think we've had conversations about this in many different scope issues over the last several years too.
Mr. Boley, question for all the parties here, is this intending to address a community member who falsely reports that someone is being a danger to themselves or others in order to have them emergency detained? Or is this, that's what I'm thinking this is intending to address, as opposed to a hospital or law enforcement making, somebody questioning that judgment call about detaining the person. Is that correct?
Madam Chairman.
Mr. Beaver?
Yeah. The important thing to read under 504 is that the statute says a person who willfully causes unwarranted custody. So in legalese, that's not second guessing the professional judgment of the medical provider.
So Mr. Beaver, this is intending to provide criminal penalties to a medical provider?
Well, it would address anybody who willfully causes unwarranted custody. So as you suggested, the third party could potentially fall under this. If you had a rogue medical provider, they would fall under that.
And Mr. Beaver, is this an existing statute already, or is this changed?
I believe it exists.
2510-126 is Ms. Reed's understanding of where it currently exists. Interesting to the county attorneys in the room. Has it ever been prosecuted? Just a curious thing. Okay, further comments, Mr. Boley?
Just, Madam Chair, I thought I'd bring it to your attention because I was told to.
Okay.
All right, so now, Madam Chairman, I think we just want to talk a little bit about the reimbursement side of things here, and this is kind of where my radar went off on Thursday. So current statute is 2510-110, involuntary hospitalization proceedings, and I don't believe it's part of the existing or the new draft, but proceedings for the involuntary hospitalization of a person may be commenced by the filing of a written application with the court in the county in which the person is initially detained. Proceedings may also be initiated in the county in which there is a designated hospital if there is a written agreement executed by the county in which the person resides and the designated hospital stating that the county in which the person resides will be responsible for the cost of treatment under Wyoming State Statute 2510-112E that are not covered by the state. And we're concerned that by eliminating that section, it eliminates the opportunity for agreements between counties and designated hospitals to cover costs. WBI currently has agreements with most counties for daily rate and a pro fees, and the pro fees, which are the physician fees, are billed separately. And today they have eight patients from 8 different counties out of that 45. So they've got a good mix from all across the state. So there's concern about their ability to negotiate as a designated hospital. Under 2510-112, liability for costs of detention. This is the new bill draft. It's right towards the end. Oh, where is it? You know where it is for me? 112. 2510-112. Oh, wait, I'm sorry, Madam Chair. Trying to keep track of my notes. It's also existing statute. 2510-112. I'm sorry, I'll read it to you. The department, boards of county commissioners, designated hospitals, gatekeepers, and other treatment providers may upon contractor agreement coordinate and monitor the services and payments required for the treatment of a person with mental illness as provided under this section. Pursuant to the contractor agreement, the department may assume any part of the expenses associated with a gatekeeper, which expenses could otherwise be the responsibility of a county under the act, including expenses for the transportation of patients to the appropriate care setting. And it appears that this section has been replaced with the cost section below, which is on page 31 under costs. And so this is where we get into what would now be the new statute. So on page 31 under cost A, it says costs include treatment of serious mental illnesses, transportation, necessary clothing, custodial care, supervision, and other services necessary under this act. C says costs must be equivalent to the state Medicaid rate. So the state Medicaid rate, I'm just going to be brutally honest, is not enough to cover the cost of delivering this care. And if we decide to go that route, it creates some very difficult circumstances for the designated hospital, because currently they're paid a per diem that's been agreed upon. And I think Director Johansson might be able to add additional insight, but we've tried to keep a balance where at least the costs are covered. I don't think anybody's getting rich off of Title 25 patients. I actually think it's an underfunded responsibility. But if we are to cut reimbursement to Medicaid across the board, an already underfunded need in our state would only be exacerbated. And so we would actually, which is kind of strange for me, but we'd actually like to leave the existing statute in place and allow us to continue to work with the Department of Health on rates. And we can get way into the weeds here as far as what billing looks like for Medicaid, but it's not as easy as it sounds on paper. I understand and realize that there are different agreements in place in each county on how Title 25 is taken care of. And I agree with our former county commissioners. It's not consistent across the board, but it is negotiated. And so I have certain facilities in our state that get no reimbursement at all to take care of those Title 25 patients. That's just part of the agreement they have with their counties. That's a memorial hospital. We have others that get a stipend, but it's only a portion of what that cost is. What I would say is that if we continue to cut, and we've already cut reimbursement to our designated hospitals because of the budget crisis that our state is in, they've received cuts for the last 3 or 4 years. Luckily, because things improved, one of the final cuts didn't take place this year, and we're grateful for that. But if we continue to cut, all we're doing is we're cost shifting, and we're going to create more uncompensated care, which ultimately is going to drive up the cost of healthcare in our state. And we're actually trying our hardest to battle that. So we could spend a lot of time on this. The other thing is that there is a program in place with the state where we can get some form of reimbursement for transportation. But again, it's underfunded. And when you're sending an ambulance all the way across the state with 2 crew members and leaving a community uncovered, you're getting 29 cents a mile. That's not even the federal mileage reimbursement rate, which is 56 cents. When you've got hospitals like WBI that at their own expense are buying plane tickets or hiring a taxi to transport a patient from Natrona County back to Sheridan or across the state, or putting them on buses at their own expense, when those patients show up and they have no personal belongings and the hospital buys them clothing so that they can go home, that shouldn't be a cost that's borne by the hospital when they're already barely covering their costs. And so we just have some concerns in this section on how that would look. And so I'm actually, again, embarrassed to say, but I'm good with where we are, at least on the reimbursement side of things. And I think the counties have found ways to work. And I actually think that there are ways work with their designated hospitals. I also think there are ways that we could continue that work and help if that's the desire. But going to a Medicaid rate is going to be really detrimental to the mental health systems. And the only other thing I tell you, there's a question that I think it was you, Senator French, that you talked about where we put these people and where they can be transferred. And it's difficult right now. COVID's exacerbated a difficult situation. Our budget has exacerbated a really difficult situation, but adolescent care, we have a really hard time placing them anywhere, partly because our rates are so low, but it's a product of our budget situation that we're in. And I would tell you that we're lucky to have a few designated hospitals that do have beds available that can help shoulder and carry the burden, because we don't have enough access to care right now at the state hospital. And we hope that as things progress and as Life Resource Center comes online, there will be additional access to care. But this has been, I've been in the industry 27 years. We've been talking about this forever, and we keep making tweaks to it that we think are better. But I think really realistically what we're doing is we're ignoring a growing situation in our state of mental health crisis. And we're going to see this get worse before it gets better. And COVID has actually made that worse. So with that, I'm happy to answer any questions and appreciate you listening to me.
Thank you, Mr. Boley. A couple, comments to the committee as you ask questions about this topic is the concerns that I presented about staying out of the conversation about compensated care, primarily because that really is the lane of the Health and Labor Committee, right? I mean, I don't have the expertise I have lots of questions about the state hospital and appropriate providers, but really that's the Health and Labor Committee's purview. And so it's, of course, we touch on that during this conversation, but want to make sure that, the Judiciary Committee stays in kind of its lane about the appropriate topics to go through under this space. So just those words of caution, Senator Kolb.
Oh, thank you, Madam Co-Chair. Allow me 1 second to agree with you. I think we're going to be on a third rail, for anybody knows, but a subway, the thing you don't want to touch at 2,000 some odd volts, because there's just no good come from it. And we're going to bog down discussion that won't be resolved here. I think the judiciary's goal is to deal with legal issues about incarceration or detention and what is right or wrong for people's rights. So I'd like to focus on that because I don't see any good coming from any other discussion about money, even though I'm, have a strong opinion about the situation facing our County Memorial hospitals and those institutions trying to deal with this. So I just like to focus on that. And I'll thank you for the information, Madam Chair. And I had one question. I'm sorry if I took time to make a comment like that, but I thought it was necessary. On the page 5, sir, on line 3, the definition change from mental illness or under mental illness as a definition, striking a medical condition to a brain disorder. Do you think that is that a benign change, or is that going to have ramifications for the hospitals and say any classification of a person who came in under a Title 25 and getting, as I dare say, reimbursement for said services? Would you have an opinion about that? Thank you, Madam Chair.
Madam Chairman, Senator Cole, I think it's a really good question. I think Director Johansson's probably going to address some of the definition changes, but I do think that it definitely changes the intent under medical definitions, and I think it could have some unintended consequences.
Representative Washington.
Thank you, Madam Chair. I know the cost issue isn't something that the judiciary really wants to wrestle with, but I think it's a critical component of this whole question about Title 25. Who pays for what? Is it the state? Is it the county? Is it the county where the apprehension took place? Is it the county where the litigation is taking place? And I think clarifying at least who's on the tab for what, I think is an important part of the legal process that we need to define. How much that reimbursement is probably a question for another day, but who's going to pay for these things? Is it the state? Is it the, whatever? But I would just add, because, this private hospital that provides a huge number of beds for this emergency detention in our state is in my county. And so it affects us differently than perhaps some of the other people on the committee. But I just like you to, if that private hospital were to no longer accept state patients, could you describe what that scenario would look like?
Madam Chairman, Representative Washit, I appreciate the question, and I think it is important. Just take a look at what the statistics I just shared. 45 state patients are at WBI today, and that's been pretty consistent for the last little while. Where are those patients going to be? They're going to be sitting in your local hospitals in their emergency rooms. We've had occasions where here at CRMC, most of the ER beds have been full with Title 25 patients. It actually took place during one of the legislative sessions while we were talking about this. But that's not the appropriate place for them to receive that care. And we talk about one individual sitting in with them. A lot of them aren't trained. And we're not dealing a lot of times with someone that's stable and just needs one-on-one. We're talking about people that are a threat to themselves or others. And so it's a lot higher level of care than I think sometimes we picture in our mind. It's not someone that's sedated. It's someone that's in there that's in crisis. And so your community hospitals is where they're going to be, or they're going to be in your jails because there aren't rooms in the hospitals. It's just going to exacerbate a very difficult situation, but we need to find ways to get them the appropriate level of care as quickly as possible so we can get them stabilized and so we can help them with treatment. But if WBI made a decision on the way they do business, because a lot of our other designated hospitals have closed down their wards and they're not doing these services anymore because there's a lot of liability, as the state is very well aware. But there were some major changes through OSHA that required huge expenditures to make sure that they were compliant with literature requirements so that people couldn't strangle themselves. But it would bog down a system that's already pretty delicate and pretty fragile right now.
Representative Provenza.
Thank you, Madam Chair. I just wanted to make a quick point to the Select Committee on Mental Health and Substance Abuse has been working on what we called House Bill 38 to determine how we're going to rework the system. And I believe that the funding model is also part of that discussion, and maybe Mr. Johansson can give a better explanation of that. But I think when we're talking about costs, we have this other kind of convoluted piece of this puzzle in which that's still moving.
Representative Provenza, are you on that committee?
Yes, I am, Madam Chair.
And what was that bill number that we passed that last session?
Yeah, it was House Bill 38.
And have you received reports in that committee from how House Bill 38 is working now that it's law?
Well, so part of with House Bill 38 is that it's enacted, I believe, in July 2022 later. And so what the Select Committee is trying to do is ensure that that bill is going to be implemented in a meaningful manner and makes sense with the healthcare providers. So it's not necessarily working right now for evaluation. We're trying to design how that is going to work.
Madam Chairman.
Mr. Bowley, yes.
I noticed that Ms. Somerville's on, and I know she's part of that subcommittee too. But that one of the major things is there's been a more emphasis put on the gatekeeping program to try and curtail what may be perceived as admits that shouldn't happen. But through legislation over the last several years, when the gatekeeper program came into effect, it's not like hospitals have the ability to go out and seek these patients, and they're not the ones determining whether or not a patient should be admitted under Title 25. That's why the gatekeeper was put in place, to make sure that those folks that really need help are being admitted. And so that's a big part of House Bill 38, I think, is a focus on that, because I also listen in and I'm part of that.
Thank you, Madam Chairman. Sir, just in regards to your comment about access to care, it seems to me that there's a huge injustice in our state when it comes to care for mental health. Why are the hospitals that you represent not opening up psychiatric units for temporary holds? The brain is a complex organ. Hospitals treat all other organs in the human body. And when the brain's symptomatic, it's symptomatic and it needs to be treated. So I'm just curious why they're not in that business when it comes to inpatient care. Is it money?
Madam Chairman, Representative Williams. No, I think the easiest thing or the easiest way for me to describe it is, would you want a Dodge mechanic working on your Porsche? We don't have enough trained staff and enough trained professionals in our state. And like I already addressed, there's a huge shortage of psychiatrists. But you're right, it's a very specialized type of treatment. And most of our small community hospitals, they're not equipped to care for them. And so even if we threw a lot of money at it, I'm not sure we can find enough trained professionals that we could stand those up. There have been changes in federal law too. That is one of the reasons that one of our providers decided to exit the business, because the liability became so high. But those that can do, we've got a few units in some of our hospitals have been able to recruit psychiatrists in, but it's very, very specialized. And so from a care perspective, I think we want the right people giving that care, and we really just don't have the trained staff from top to bottom that could care for the patients.
Thank you, Madam Co-Chair. I think maybe tell me what you know of this, but at Sweetwater County Memorial Hospital, they experimented with having psychologists on staff. I can tell you it's about $500,000 a person to get one, and the reimbursement is abysmal You're getting Medicaid, Medicare reimbursements. It's a huge liability. I think if your facility is big enough, maybe you can afford to lose that much money. But when your facility is not big enough, it becomes economically unfeasible for them to provide that service. Not because they don't want to. I think they all want to try to do as much as they can for the people that live in the community, but there's sideboards to the cost of this. And I guess that's what I knew about that, because they were losing 8 million a year at one point, 8 million. And I don't know how you can sustain that. So the issue it is, I mean, I see it as money, but I guess if I'm wrong, please expound on that. Thank you.
Mr. Boley, can you speak with such courage?
Madam Chairman, Senator Kolb, so I'm aware of what happened in Sweetwater County, and so we're really going back. But this is kind of when, in my tenure in this position, this is kind of when we hit a pinch point. The state had a certain amount of money that was budgeted for Title 25 for mental health issues, and we were surpassing that. And it was when Director Forsland was the director of the Department of Health. Task force were set up. A lot of times it was referred to as the field of dreams, where when we build access to care, then we started seeing use of that care. And there were certain folks that felt like people were making bank on that, but the truth was they really weren't. Actually, Sweetwater County, because they had 2 psychiatrists, they started delivering really good care there, but it was really expensive care because it's highly intensive and it costs a lot of money. And it had a very negative impact on budget. So there were some things that were done in 2015, I believe it was. That's kind of when the gatekeeper program came about. There were some changes made with contracting with designated hospitals. There was a lot of emphasis given to the fact that there was question whether or not that care was actually needed, or whether the psychiatrists were building their practice. And ultimately those 2 psychiatrists, because of contracts and other things, decided to leave the state, which left a big hole. And like I said, we look at the WWAMI program, we have very few of those students that are going to come out and be psychiatrists. The ones that come out really don't want to do this kind of mental health. And so, we're looking at all kinds of options to increase access to care. We're trying to do some telepsychiatry and some other things, maybe using ARPA funding, but I mean, we're way in the weeds here, but it's difficult. And money was a portion of it. It was mainly the budget side of things that I think drove a lot of that. Money helps, but finding the trained staff is something that, yeah, if you threw a lot of money, you might get some in, but I still don't know if we're going to be able to combat this the way that we need to in our state.
On that same note, I just wanted to explain that the hospital's doing financially fine. The issue comes, and it's no way a negative comment about the care that was given. It was good care, but it's just so expensive and the reimbursement is so low. It's just very difficult for our small communities to help in this way.
Yeah,
Thank you.
All right, with that, Mr. Boley, why don't you just stay where you are, and because I think there might be further questions that you might be able to assist with. But we'll go to Mr. Johansson on Zoom. Welcome, Director Johansson. Good to see you.
Thank you, Madam Chairman, members of the committee. Stephen Johansson with the Department of Health. I appreciate you letting me testify virtually today, even though I'm right across the street. It's very helpful as you can imagine, a lot of multitasking is taking place at our agency right now. Just a few brief comments, Madam Chairman, about this bill draft and some of the things that have been mentioned. And I also heard my name dropped quite a few times. So if I don't address everything, happy to stick around and answer questions that may have been asked earlier in the morning. First and foremost, I think there's good provisions of this bill. The department is not supportive and not unsupportive of this bill, given that it's a working draft. And I think to some of the comments that I heard this morning, I think there's a lot of work to do here with this product, depending on the direction this committee or others would want to go. There's a lot of volume in this bill and a lot of changes to the statute. And I sympathize with the folks who have been working on it, because it is very difficult in behavioral health policy or law to generate consensus and interpretation is really just varies across the board with what legal terms in terms of art actually mean in practice. But like I mentioned, Madam Chairman, I think some positive things in the bill that the Department of Health has reviewed. I think clarification around what is currently known as gatekeeping and referring to those individuals or positions as treatment coordinators is certainly in line with what the intent of that provision of statute was that I was involved in years and years ago when some of those clarifications were put into statute. And I think the department is generally supportive of some of those changes and really getting clarity of what that role is at the local and the judicial level. I do think with some of the changes, Madam Chairman, as you mentioned before, sticking to kind of what is in the law here, what's in the purview of judiciary or this committee, changing definitions, like I mentioned before, it will generate consensus among some and lack of consensus among others. Looking at definitions of mental illness or serious mental illness, I think the intent is pretty in line with what is already in statute, essentially defining serious mental illness, basically what is defined now in statute as dangerous to self or others. Someone who has a propensity in the eyes of an expert or a judge ultimately that will cause harm to themselves or to others or be unable to provide basic care. Again, the terms, the legal terms and the terms of art change here, but I think the intent is still clear that what this tension that we're dealing with is defining mental illness or defining serious mental illness versus what's in the public interest of public safety. If someone's rights need to be curtailed because they are dangerous. So I would just encourage committee consideration of those tensions where I think operatively what's in statute today functions and incorporating what most people in this field know as clinical definitions like serious mental illness into that more public safety definition could be problematic in interpretations going forward. Number two, Madam Chairman, sticking to content in the bill, the medical review committee idea, certainly understand where that's coming from and what the intent is. I do want to point out for the committee that would be an administrative cost for the Department of Health, certainly something that we would have to look at standing up and what that would take to essentially have folks on call to service, Title 25 cases, courts, judges to provide that sort of medical review. And again, not taking a stance of opposition here, just knowing there is an administrative and a fiscal need. Would also point out that with provisions like that, or some of the discussions we've had this morning on Department of Health role in costs or rules, there's another fundamental tension between local control and state control. And I think what we have now in statute divides that up. And again, doesn't always make folks happy. And there's certainly problems with how it operates. But for example, giving the Department of Health more authority and review over in this medical review committee over medications, things of that nature, I do have some concerns about stripping the judge and the local ability to determine, if medication should be involuntarily administered versus, getting the state department involved. At a moment's notice or during this hold period could just provide some administrative bureaucracy that may not be necessary, but happy to discuss, happy to be a resource if this moves forward on what that could look like. Just a few more comments, Madam Chairman, and I promised I would be brief. In terms of what's pointed out in the bill with the state hospital, much of this has already been mentioned. Just want to clarify for the committee that while there's still quite a bit of frustration, and I understand that in our local communities about the wait list at the state hospital and various protocols around that, as Mr. Boley mentioned, we are finishing up, and I cross my fingers there, a massive capital construction project at the state hospital in Evanston and the Life Resource Center in Lander. We're not there yet. But we do anticipate the ability to move patients in and out of both of those facilities, hopefully decompressing your emergency rooms and your Title 25 systems in your communities. We are on track to get there. COVID-19 pandemic delayed some of that. Some additional physical plant changes after the construction, some modifications and renovations had to take place and are currently taking place. But we're working through that to make sure we can, as much as possible, decompress that waiting list. In addition, in this bill is mentioned pretty explicitly that, in terms of the state hospital and Department of Health's role, when it can't admit a patient, which again, I understand that's a frustration that we all have today when there are waiting lists. We do, just to clarify for the committee, once the Department of Health and the state hospital have the involuntary hospitalization order and essentially a patient is in our custody, what happens right now is the referral process does start. We look every day for a placement for that particular individual. And as Mr. Boley pointed out, frustratingly for all of us, the levels of care just aren't always there. We have facilities that either can't or won't accept patients, both here in state and out of state. And it's just a constant struggle that we have to find placements for folks while we wait to admit them to our facility. But just so the committee knows, that process does take place every day with our admissions coordinators at the state hospital. And it's not perfect, but it's something that when I see that written explicitly in the bill, it's well received because it's something that is already part of our mission. And then finally, Madam Chairman, it's been mentioned with the House Bill 38 kind of overlap here. That ended up being House Enrolled Act 56, just for the committee's awareness, which is one part of the continuum of care when we talk about behavioral health that I do believe is in many cases directly related to Title 25, but also has a lot of indirect impact on this system, both on the front end and the back end of Title 25 hospitalization. Just as a quick update, Madam Chairman, for the committee, that work with House Bill 38's implementation, in my judgment, is going extremely well. It's not something that gets implemented tomorrow. It's a long-term reform of approximately $100 million state general fund system that funds community mental health services through our community mental health and substance abuse centers. House Bill 38 really looked to recognize the reality of the state's fiscal environment, as well as what's the fundamental role of the state in providing community-based care for behavioral health. And it ultimately prioritized those dollars and those services towards a select group of individuals, including Title 25 patients, Title VII patients, Department of Corrections, folks who have needs coming out of institutions, Department of Family Services, high needs children and families, and those who don't have a pay source, so indigent folks with higher behavioral health needs, really in an attempt, which I think is relevant here, to provide both front end and back end community services, directing our providers that this is your first priority with state dollars. I am very optimistic, Madam Chairman and members of the committee, that over the next 1 to 2 years of that implementation, we will see some improvements in our ability to connect patients who may go through a system like Title 25 to services in the community earlier. And then on the back end, when folks are receiving treatment or being held in institutions like WBI or the state hospital, one of our primary challenges is how do we get folks who are stable and ready to be discharged to an appropriate setting that right now is often not available in our communities. This will obviously not be perfect, but I think getting the state financial incentives right and clear direction to that system of care in the communities will go a long way. So, Madam Chairman, I will wrap up. I know there were several comments and questions about the Department of Health, so I'm happy to stand for those. But like I mentioned, we'll take a neutral position on this bill and certainly be a resource to members of the committee or others in the working group if it does move forward. Thank you.
Director Johansson, thank you so much. Great comments. Representative Washut has some questions.
Thank you, Madam Chair. Director, just a quick question with regards to the transportation capabilities of the Wyoming State Hospital. I think we heard testimony a little bit ago that the state hospital has one transport unit. Is that accurate? And if so, is there any consideration of expanding that capability to assist getting these patients to and from places around the state other than the Wyoming State Hospital?
Director?
Madam Chairman, Representative Washit, thank you for that question. That statement is generally accurate. I will just clarify that the state hospital has a transportation team. So it's not just one, there could be multiple transportations taking place at the same time, but absolutely it's a limited resource. We do our best when folks are committed to our custody, but maybe not in our facility, to transport them to the state hospital or from wherever their location is if they're discharging back home or to another facility. But it is very much, sir, a limited resource, which is, as Eric Boley mentioned, why we do have the ability to reimburse providers for transportation costs. And it's certainly, again, not perfect, but to be, not to be facetious, but better than a sharp stick in the eye is kind of my mantra here, when we just don't have the ability always within our budget to pay what everyone needs or what everyone wants. But specifically to your question, Representative Washit, we do not have plans right now without an additional appropriation or staffing to expand that transportation team, but we have made efforts with our providers, and WBI has been a good partner here to try to make the process as efficient as possible. For example, instead of calling us the day that someone is discharging, to have that relationship where we work back and forth with the facility in the days or even weeks prior to a discharge, so that we can try to do our best to align those transportation resources. And Representative, I know that's not a great answer to your question, but I think I would concur with you that it's definitely a limitation we have on the transportation side of the hospital.
Senator Cooper.
Thank you, Madam Chair. Mr. Johansson, and I believe that you may be the right person to answer this question. We all agree that involuntary hospitalization is a serious thing that needs to be addressed properly. Who do you believe is the proper person to make that determination? Is it a physician? Is it somebody that's licensed clinically? What is the right answer for that, and what should the language be?
Director?
Madam Chairman, Senator Cooper, another great question, and I'll give you just Stephen Johansson's opinion here, having worked in this system for a number of years on the state side. I think the appropriate decision maker when we're talking about Title 25 civil commitment, because it involves not only behavioral health care, but also civil rights and judicial process, the appropriate determining authority is really the court, is really the judge. But based on, clinical recommendations, evidence from, medical evaluations, behavioral health evaluations, and frankly, what's been added to statute over the past several years with gatekeeping, or if the term is changed to treatment coordinator, the idea there is the judge being able to be educated on what resources are available in the community or not that would influence the decision to issue the civil commitment or to release the hold. So I think in my professional judgment, it is certainly the judiciary that needs to make that call when it's a civil rights issue, based on the best recommendations and evidence possible from physicians, if possible. And I think statute spells it out right now that if an involuntary commitment is ordered by a non-physician, it needs to be reviewed by a physician, or I believe APRNs are allowed, could certainly get back to you on those specifics that are in statute today. But again, to reiterate, I think it is certainly a judicial call, since it involves due process and civil rights, based on those the expert testimony and evidence from the folks that are specified in statute.
All right, additional questions for the director? Representative Craigo.
Thank you, Madam Chairman, and I apologize for getting into this question regarding cost, but because I think it's really tied to the process. I'm not talking about necessarily amounts of cost, but trying to figure out a way to make this process better for all the counties and the state as well. And so I apologize, but one of the questions I have, and I don't know who the better person to ask this, whether it's the director or Mr. Boley, is there a large difference in reimbursement from the counties versus the state? Are we talking a huge difference on the first 3 to 6 days versus the next 15? I mean, or not? And is that something we don't need to be worried about if we if we go down this road of talking about efficiencies of maybe the state handling all costs outside maybe transportation or something, and legal costs that the counties are going to continue to provide, if that question makes sense.
Either one, Mr. Bowley or Director, if you'd like to take it.
Madam Chairman,
We're looking at each other through the camera.
Hope that works.
You want to go, Director?
sure. Thanks, Eric. Madam Chairman and Representative, it's another good question. And in my experience, going back to 2014, 2015, I think there's high amounts of variation in what the state pays when it takes over financial responsibility versus what counties pay. We noticed that when we collected some data years ago to see what those variations are like. But to be quite honest, I'm not privy to contractual relationships between counties or counties and other facilities of what those rates are. I think the fundamental issue that's being pointed out and debated here is what should payment look like in those first 72 hours or under county responsibility? And the philosophical question is, should that be standardized? Does the state have a role in standardizing that? And there's pros and cons on both sides of that, where I think some counties, and I believe I will not throw him under the bus, but I had a good conversation about a year ago with Mr. Beaver about this, where I think some counties are saying, hey, we're an attorney's office. We're not good at medical billing or processing claims. You all are good at that. Help us do that. And we could certainly do it. But what comes with that, to the tension that I pointed out before, is, again, state control versus local control. So if the first 72 hours and the costs and the reimbursement are standardized in that way, the state would, in theory, institute kind of standardized rates, what we generally pay. And I think that would generate some concern. I'm sure Mr. Bowley will speak to that, of what's appropriate, and are we unduly putting our hand as the state on market mechanisms where counties can find the resources or try to find the resources that best suit their needs. But I will say, just wrapping up and to be very simple, there's a lot of variation, as far as I understand it, in what counties are being charged from hospitals versus what they ultimately end up paying.
Madam Chairman, it's actually not necessarily a follow-up. It's a different question, if I may continue. Do we have a number on how many facilities the state has contracts with to provide Title 25 services around the state?
Madam Chairman, I'm sure Director, I use his name pretty freely here because we've been in the trenches together on this, and we've been working together on this important topic for a long time, and it's a collaborative relationship. But there are, I'm not exactly sure how many we have left right now. Do you know, Director?
Madam Chairman and Representative, just a quick clarification. So specific contractual relationships for this provision of care, it's not entirely accurate. What we did years ago to achieve some efficiencies in the system is run all of our billing and our kind of administrative processes through the Medicaid system. Doesn't mean that it's a Medicaid program or just for Medicaid clients, but we were able to really, advance our claims processing and our provider enrollment by leveraging that system. So happy to provide you a breakdown of all of the different types of providers that we have enrolled to provide various levels of services for Title 25 patients. But it basically breaks down in the following way. In terms of what we have historically called designated hospitals, those who have beds that can provide psychiatric care, that is basically WBI. Cheyenne Regional has a few psychiatric beds, as does Ivinson Memorial in Laramie. And I believe, don't quote me on this yet, I'll follow up with you. I believe Campbell County has a few psychiatric beds that, again, very, very difficult to staff and have that level of care. And then a representative around the state with our general hospitals, they often hold or provide care typically on a non-psychiatric basis to patients, and are also enrolled as Title 25 providers with us. And essentially we pay them for their professional services, outpatient observation, those types of services, but it's not a psychiatric level of care like the state hospital or WBI, for example. But happy to provide you the breakdown of all of the providers we have enrolled over the past couple of years for Title 25.
Thank you, Madam Chairman. One more follow-up, and this would actually be for Mr. Boley. If we take the discussion of cost, let's assume everybody was paying the same daily rate, no matter whatever we decide that number was. Would there be some efficiencies? Would it be beneficial to the providers around the state if all the billing came from a centralized location, i.e. the Department of Health? Would there be some operational efficiencies in a system like that?
Madam Chairman, Representative Craigle, that's a really good question. And I think there's definitely some interest around the state in looking at that. It would require a big revamp of what we're doing, but I do believe that there might be some benefits to that. And I've talked to the director about that a couple of times, and I know there are some folks in the state that are interested in leading the charge on that. So I do believe, and in answer to your first question, it's all over the board. I mean, there are examples I could give you of there's a set amount of money that comes and it doesn't cover the expense, but they get that. There have been pieces of property traded to ensure that the Title 25 patients are taken care of. Natrona County is a whole different animal, the way things are set up now with the recent acquisition of Wyoming Medical Center by Banner and agreements that were put in place. So it is all over the board, and it's not consistent, which I think our former county commissioners can attest to.
One more line of questioning. So along that same, back to that same topic, I guess, and then sort of follow up is, do the providers have issues with uncompensated care in this under Title 25, especially for that first 3 to 6 days that the counties are responsible for the cost? Because I know just anecdotally, we get into situations where counties get into arguments on who's really responsible for that. You know, for instance, somebody from Buffalo gets picked up in, let's say, Casper or Cheyenne, and they're from Buffalo, but they get titled somewhere else. And then we have a discussion about who's responsible for that, the county of residence or the county initiating the title. And then we have some back and forth, and might take a long time to sort that out, or maybe it never gets sorted out. And, you know, for instance, WBI is sitting there and they're having to argue with somebody to get paid for services they provided.
Madam Chairman, you're doing a great job for me, Representative Craigle, but just going back to my former hat as a hospital CEO in Lincoln County, we didn't have a lot of Title 25, but it was always contentious with the county determining who was responsible and how much. And it took a long time. And I would imagine that in some cases it probably does add to uncompensated care, although normally what ends up happening is county commissioners and hospitals get together and they negotiate something, but it does take a long period of time. And then you've entered the whole different realm of where that patient is coming from and who's responsible, and then who ultimately takes the care. And that's one of the issues that WBI is constantly dealing with, as well as some of our other designated hospitals.
Thank you.
I'm just going to make some comments and we'll get to Senator Kolb and then Representative Larson. Recognizing the time is 11:50 and this is a large topic. Just kind of wanting to get a sense from the committee right now, not a vote, but do you want to bring this topic over into our next meeting? Just a nod of the heads, probably, yes. Looks like everyone wants to continue to have this conversation at the next meeting. Okay, good. So we have that sense. So now we can understand maybe the line of questioning and comments we have, and for purposes of additional public comment from those that might be interested in providing it, recognizing that the committee is not going to adopt a bill draft today and take it off to session. We're going to continue to work it. And so the committee's comments can be directed at directing questions to the stakeholders and those that can provide us the necessary information to bring it back for our next meeting would probably be a good use of our time management here. Another particular item to consider for the committee to take would be whether or not you want to turn the final version as presented by the county attorneys into a bill draft or not. So just kind of planting a roadmap here for what the committee can do in order for us to manage, the next 10, 20 minutes of our time here this morning. So with that, Senator Kolb.
Thank you, Madam Co-Chair. Well, I'd like to first thank the past administrator for Lincoln County sending in patients to Sweetwater County for care. I think that's really part of it's kind of and it's joke, but The issue is I see it as, and I want to hear your opinion, equality of care across our state. I find it reprehensible that we have all these different levels of care for whatever county you may happen to fall into for these type of service needs for, say, for Title 25. And I think the only group that I see is Department of Health who can provide oversight. So we have an equal level playing field as best we can for the folks across our state that we all represent. So I think after listening to this, I'd like to hear if you think that's a way to go. I mean, I understand the Department of Health's position that obviously it's a whole new world that they be into, but what can we do to unify care and to make it uniform? I mean, in fairness to people, what choices do we have? I'd like to hear what your opinions are. Thank you.
Mr. Boley?
Madam Chairman, Senator Cole, a great question. And it kind of does go back to money. This is underfunded, and it has been for a long period of time. Access to care, creating some centers of excellence around the state and building the ability to care for those patients. Not every hospital is the right place for these people to be. They need care in the appropriate settings, but building additional access to care that is appropriate makes the most sense. But we've been, unfortunately, this program, along with a lot of the other medical programs, has been cut to the core. And so even if one of the problems that we have is even if we can find someplace outside the state that can even accept these patients, our reimbursement rates are pretty abysmal. And so outside providers that could give the higher level care, we're not very high on the totem pole all the time as compared to other states around us. And so I think, unfortunately, it's not about money, but it is about money because it's an underfunded mandate. These folks need help, but we don't have those centers of excellence. So it would take an investment to create or to build that. And I think some of the work that's happening with the House Bill 38, creating community-based services where we can help people be stable and make sure that they're staying on their drug regimens and seeking follow-up care and things. There's a lot we could do that we haven't really explored for a long period of time. We've always focused on one small component of this as opposed to the big picture. And I really believe it's going to take an investment in other services to shore this one up and make it better, if that makes any sense.
Yeah, I didn't really mean that.
I'm sorry.
That wasn't really what I was asking. I think the old joke about how to eat an elephant, it's one bite at a time, right? I think we have what drives, the question, I think, is what's first legal and fair, and then wherever that answer goes to, then the cost will follow. So it's a stepped process. We just can't solve that budgetary issue. I mean, it's just, I think, unreasonable to think it can go somewhere. But I think we can talk about what's equal and what we can do for the across the state of Wyoming for their level of service. And commenting about Medicaid, Medicare reimbursement and then the state's reimbursement, well, one's bad and the other one's worse. None of them are adequate enough, but we're not, like I say, I think the conversation right here is, what do we really need to do? And then the cost will be we calculated later. So I just like that. So just maybe understand my question better. So my question is do you think we need a uniform oversight, nothing to do with money, but we need to have a uniform way of handling people across the state when they're in these type of situations with the Title 25 issue?
Madam Chairman, Senator Colby, I'm sorry, I misunderstood the question. I think that we're supportive of that idea. I think that's one of the reasons that we're hoping hoping that this bill proceed is so we can create those consistencies across the state. So the system is administered the same way. And then, I agree with you. Then we can start to look at how we deliver that care. So I do think I apologize for not understanding the question.
Madam Chairwoman, thank you. A question directed to the director. This is off topic on the proposed bill, but you mentioned the new facilities in Evanston and Lander. Are they totally operational or partially? And a timeframe to get them totally?
Director?
Madam Chairman, Representative Larson, thanks for that question. We are fully moved into with patients to the new state hospital facility in Evanston. The final phase of that project is really some changes to the administrative building, which will wrap up this fall. So we anticipate the project to be fully complete by the end of this calendar year. But we are fully moved in with patients and providing patient care in that new facility. With the Life Resource Center project in Lander, as you are all may remember, in the early days of the project, we ran into some significant delays regarding finding ACM or asbestos around the facility when the buildings were being bulldozed and demolished. So there were some delays there, some associated COVID delays, but we do anticipate the majority of the work at the Life Resource Center project to be complete also by the end of this calendar year. With licensure and CMS certification, we anticipate beginning to move patients fully into that facility in the early part of 2022. Where that really has an operational impact, Representative Larson, is with many of the long-term patients that we currently have at the state hospital. For example, geriatric psychiatric patients that we've been unable for years and years to place at nursing homes, for example, in the private sector. They will be able to be transferred over to the Life Resource Center, have a better, more suitable level of care in a nursing home environment for them. And that also has that decompression effect that we discussed on the state hospital wait list, because currently we have quite a few long-term patients taking up short-term beds. So really, I think the best answer, Representative, is end of this calendar year, but certainly fluctuating with the contractors and the work that's going on site. If you haven't been there, the buildings that are being finished and that have already been handed over to us at the Life Resource Center, I've been very pleased recently with their quality, and a lot of those buildings are already in use. For example, the Recreation Center, and Department of Health is just very grateful for the work that's been done and the investment that the legislature has made in those facilities. So bear with us, be patient. I know it's a long time coming. I think we'll be there shortly. The end of this calendar year and into 2022 is when I think we'll be looking at full operations at both places.
Okay, we are running short on time, committee, but it's your lunch hour. So we have Miss Somerville, and we'll get to Representative Provenza. She has a question. Miss Somerville, is she in the waiting room still? We'll bring her on. And so we'll hear from Representative Provenza and then go to Miss Somerville, who has some public comment as well.
Thank you, Madam Chair. Part of the discussion today has been that we have county funds and we have state funds. But I would argue that we also have the ability to have a third source of funding through Medicaid expansion. We know that hospitals, and maybe Mr. Bull, you can speak to this, that we have a lot of uncompensated care because people don't have health insurance. We don't have a way to necessarily pay for that. And when you don't have compensated care, so a patient can't pay, then we lose funding in our hospitals. We don't have funding for ambulance services, things of that nature. And would we be able to maybe provide services for things like treatment of mental health, or as Representative Williams brought up, some of those issues, if we were able to accept that third source of funding? I mean, what does that look like? Because I think we've danced around this topic of we don't have enough money, we don't have money to give. But to me, it appears that we can take some money that would otherwise be owed. So I don't know how does that play into this with Title 25?
Mr. Boley, would Wyoming's participation in the federal Medicaid expansion proposition benefit in any way Title 25 patients?
Madam Chairman, Representative Provenza, it would. There are some great benefits that would come. We've got 25,000 people, I think, in our state that would qualify for that, many of whom suffer from mental and behavioral health issues. They don't have insurance. They don't have coverage right now. there would also be a shifting of how funding is used because of the expansion. So it would actually give us more money to deal with this situation and other mental and behavioral health issues. So it would be a big benefit, not only to this, but others.
All right, thank you. With that, Representative Yen? Again, let's keep it within committee number 1.
Sure, Madam Chairman, thank you. Yeah, I mean, just to expand on that a little bit. So we're talking about the cost of involuntary commitments. And so to reduce that cost, one way would be to reduce the number of people who are involuntarily committed, right? So do you think that preventative mental health measures, as well as access to outpatient mental health services, would help reduce the cost overall for all parties involved? Thank you, Madam Chairman.
Mr. Bowley?
Madam Chairman, Representative, yes, if they could get preventative care and constant care before it reaches a crisis stage, obviously it's going to drive the cost down. It's going to eliminate or decrease the number of Title 25 patients, and it'll give them the ability to stay within the treatment plan and hopefully get better. So there are benefits, obviously, and you've done a great job of explaining them.
All right, with that, we're going to go to Ms. Somerville. Ms. Somerville, thanks for hanging in with us for so long. Ready to hear some of your public comments. We are short on time, as you are painfully probably aware. So if you could keep those short, we sure would appreciate it.
Thank you, Madam Chairwoman. Andy Somerville, Executive Director with WAMSAC, which is the Association for the Community Mental Health Centers. And I try never to stand between legislators and a lunch break after a long meeting. So I will be very brief. Committee members, you have received 2 documents from me this morning. I apologize for not being there in person. I have a kiddo out awaiting COVID-19 test results from school today. You have 2 documents from me. One is comments based on the draft submitted by the county attorneys. The other one is a document aligned for comments with the working draft that's there. Mr. Bowley has touched on several of the issues that we've highlighted in those documents. And so I just want to highlight a couple. The community mental health centers are the gatekeepers and the evaluators on the ground in most places in the state. The House Bill 38 or House Enrolled Act 56 has continued to move that forward and really put that within the responsibilities of the community mental health centers. And so we wanted to touch on the physician testimony aspect. We have the same concerns as Mr. Bowley expressed with making sure that we're really aligning that statute with the mental health resources that are available in the state. From our perspective, that professional testimony is appropriate to come from any of those licensed individuals listed in the examiner definition in your working draft right now. And probably 95% of the time that is coming from a licensed professional counselor or a licensed clinical social worker in Wyoming. And that is certainly the resources when we respond to hospitals that don't have psychiatric staff to do evaluations. Those are the resources that we use. Wanted to mention on page 57, there is a staff comment about repealing a section of House Enrolled Act 56, a paragraph that sets out prioritizing behavioral health centers for gatekeeping. That there's some additional language in House Enrolled Act 56 that lets the Department of Health pay for those services if it's done by a behavioral health center. In trying to move 2 very large projects at the same time, both this bill and the behavioral health reform bill that passed last session, it's important for us, I think, to continue those conversations to make sure we understand what the priorities are. So right now, we would recommend that paragraph be updated from gatekeeper to treatment coordinator and kept in that draft bill. Otherwise, we do have some comments around the mental illness definition. We want the committee to understand that the definition as it's written in the working draft does highlight most of the causes or diagnosis tied to Title 25, but it's not all encompassing. In addition, it would probably be appropriate to have some additional conversation around degenerative brain disorders such as dementia and traumatic brain injuries as well. Although those are medical conditions, they often can present in a Title 25-like environment with mental health symptoms that have developed because of those medical conditions. However, the backside to that conversation is a Title 25 hold and The resources available in the communities are not necessarily the best long-term placement to help that patient. Wyoming lacks significant infrastructure to be able to provide appropriate care and placement for those individuals. And Madam Chairwoman, the last thing I wanted to add is just kind of a additional lay of the land. In addition to being the gatekeepers and the evaluators on the ground, the community mental health centers provide, we have 4 locations that have what we call crisis stabilization services. Those facilities can take Title 25, although not all of them do, due to resources, facility structure, a lot of things. But we do also keep some Title 25 patients at our crisis stabilization centers. So we're deeply involved. I'm going to wrap those comments up, and I'm happy to answer any questions if the committee has them, and happy to provide more comments and feedback for the next meeting.
Thank you, Ms. Somerville. Any questions for Ms. Somerville? All right, seeing none, I appreciate you being here and hanging in with us this morning.
Thank you.
Is there any additional public comment in the room? All right, seeing none, public comment is closed. Committee, back to you. Representatives Monitor.
Thanks, Madam Chairman. I would make a motion to move this bill forward to our next meeting with the suggested changes from the county attorney, or for at least from Ms. Reed. I'm not exactly sure if it's a county attorneys association or it's a working group of, I've heard from a couple of county attorneys over email this morning. They're not super excited. So funny that. So move that forward with the suggested changes, and I think there are some probably other amendments people would want to bring. And so maybe LSO, if they track some of those, we can have some specific kind of decision points. I know with a draft this big and a whole lot of issues, we certainly can't solve them all. But I do think there are 4 or 5 tweaks that we could do as a committee bill to move the ball forward. And that's probably all anyone's asking right now, without doing reimbursement and without a couple of the other bigger issues for the legal judicial process. And so maybe if we could suggest LSO to kind of have those specific questions of which way we should go.
I'm going to narrow down your motion. So it's your
like it.
motion to direct LSO to turn the final version of the county attorney's working draft into a bill draft. Is that correct? Is there a second? Seconded by Senator Cost. All those in favor say aye. Aye. Any opposed? That motion has passed. Are there any amendments to the proposed bill draft based on that rewrite final version we have that the committee would like to discuss? Representative Crago.
Madam Chairman, and I don't know if this is an amendment or if we should just possibly request another bill draft with the alternate route. And I don't know, maybe I'd leave this up to your advice or to the chair's advice, both of you, whether we bring another draft that kind of incorporates the theory that we would transfer all costs to the state, except obviously legal costs. Prosecutor's office would continue to handle that. Costs of transportation would still be handled by the counties, but the actual treatment costs at the facilities would be billed and handled through the state.
Motion by Representative Crago, seconded by Representative Oakley. And discussion on the motion?
Thank you, Madam Chair. So I think from what we've heard today, I'll, keep it brief, but we've discussed the state umbrella idea, and just repeatedly, I hear there's a high variation in cost. I know at the risk of raising the ire of Madam Chair, but we've heard comments from people on the ground, Senator French, Senator Kolb, people who've dealt with it at the county level. We've heard about the variation in treatment that ends up being available for Wyoming residents. And that's really what we're getting at here, right? For our constituents, and perhaps if we had it, if the Department of Health was able to leverage costs, that would equalize costs for people throughout the state. And then we could maybe get rid of the Medicaid rate that is so offensive to them, because then the state would be in a position to negotiate that. It just makes sense to me. I think certainly it's time to have that conversation. We've talked about resources in 2 different counties. This alleviates all of that. I have seen some language specifically, so it would be page 30. lines 1 through 3, which says the county paid for it, change that to subject to the provisions in this act, the department is liable for the costs of.
All right, so slow down. Remember, Mr. Fuller is trying to listen to what your
Sorry, I'm
intention
trying
will
to
be.
hurry.
And what, we have time, so let's slow down because this is a big topic and you can tell then the committee is interested in it. So don't want to do what we have historically done, which is a lot of big last minute work on a very significant topic. So take your time and let's make sure Mr. Fuller understands what this motion is. And so everyone understands also what this motion will be.
Okay, so, and when I say page 30, this is of the draft by Miss Reed, so that it's the 33 page. Lines 1 through 3, which says the county in which a patient resides is liable for the cost, changing that to, again, subject to the provisions in this act, the department is liable for the costs of emergency custody, inpatient hospitalization, and this directed outpatient treatment. And then whatever conforming language as far as taking out county of residence, that so the competing interest between counties would be alleviated. And we, I think, would come up with a much more fair, equal treatment, something that we've just over and over and over the struggles with the counties. I think this alleviates that, but that's with conforming language is as simple as the amendment would be.
That's seconded by Representative Wanitzer. I'm just going to have, no, okay. Okay. When you do this. So that was the discussion on Representative Craigos. Yeah, that you're right. So that was just discussion. All right. Representative Wanitzer.
Thanks. I want to clarify the motion, Madam Chairwoman, that the motion is probably actually for another bill draft with the incorporation, I think, from my good colleague to the left, only because I bet it's going to have a financial impact to the Department of Health, which will, I don't want to overlay with the good work that's been done and the policy questions on the legal proceedings versus what I think is a very different policy question that has everything has financial, but much larger financial ramifications of what Representative Craig is asking. So I just want to specify it's a separate bill draft request with Representative Ember or Oakley's suggestions.
Claire's Mud Committee. Let's go to Mr. Fuller and see where he's at.
Yeah, Madam Chairman.
When Mr. Fuller responds with, let's figure out what it is you really want.
I think there's a couple different ways this could be approached. And the first is, I understood the first motion that the committee passed was just to incorporate the changes in the county attorney's version into the working draft. That includes language on costs currently. So one option is to simply prepare an amendment that would present the language that's been discussed. That could be either voted up or down in that bill, or alternatively, a separate bill draft that would just cover the costs as a standalone issue that would amend, really, I think our current statute to address that issue by itself. That, I guess, that's a couple of different options, but certainly would appreciate clear direction from the committee where it wants to go with this.
Thank you, Mr. Fuller. Very helpful advice. Representative Crago, you heard kind of the two options. Would you like a drafted amendment or do you want a full substitute bill? And would that substitute bill just address cost is my question.
So I think both, actually, Madam Chairman. I think what I'm proposing is that we take the proposed bill that Ms. Reed prepared and amend it to include the provisions regarding state assuming all costs for Title 25 treatment, but it would still be a separate bill draft. And the reason I wanted to go those two different routes is when we get to the next meeting, if between now and then we learn a reason why that is not doable or not smart to do at this point in time, we can still go down the road of changing if we decide to do so as a committee, we can still go down the road of at least incorporating Ms. Reed's amendments into our current statutes, if that makes sense. So I want to do two different bill drafts, but I want to use Ms. Reed's as our basis for my second bill draft.
Mr. Fuller, any questions?
Madam Chairman, I understand Representative Craigle's request would be basically the same bill except for that language on costs. So it'd be two of the basically 60-page bills. The only difference being, one's going to handle costs as the county attorneys has drafted. One's going to handle costs as Representative Craigo has outlined in his motion.
That's what you want?
Yes, ma'am. Madam Chair.
Is there a second on the motion, seconded by Oakley? Discussion, Co-Chairman Olson?
Yeah, I just have a question for Mr. Fuller, and I'm not sure if this would confuse it, but would it be inappropriate to, in Miss Reed's, we'll call it Miss Reed's version of what Representative Gregor wants, to include that as a staff comment? Because it's one section, right? So we could have it all in one place. Let's say the committees discussed this option for a change in cost, and just so we don't have two different floating bills. Would that be possible?
Madam Chairman, Chairman Olson, definitely.
How do you feel about that, Representative Gregor?
I'm not opposed to that either, Mr. Chairman.
Keeps it.
Make a decision, candidate. What do you want to do? Representative Craig, do you want the staff comment or do you want a separate bill? Sounds like you wanted a separate bill.
I do.
Okay.
I mean, that's my initial request.
All those in favor of Representative Craig's motion to do a separate bill with that particular change provision, say aye.
Aye.
All those opposed? That motion has passed. There'll be two bill drafts, one with the proposed changes on costs and one without. Senator Kolb.
Well, I wish to, thank you, Madam Chair. Co-Chair. I tried to get this through, so I tried to amend your amendment, but of course I didn't get anywhere with that. My question is this: is there an opposition to having the first bill draft from Ms. Reed, call it that, stripped of any provisions for cost, any cost conversations, and excluded out of that bill totally? In other words, there'll be no cost references in that bill. And then the second bill, the one that we just proposed to have drafted separately with costs and, the issue with the whole state. I was wanted to know if there was opposition for having a bill that was just a bill about legalities and such, and nothing to do with costs. And as opposed to one, instead of having this mixed one that has some costs in it, and the Ms. Reed's bill.
Senator Kolb has a motion where he'd like a third, I'm not being facetious, a third bill draft stripping the bill of costs.
Well, honestly, yes, but I wanted to try to amend the first and have a conversation about the first amendment. And so we could talk about it then, see if that people were amenable. But I guess at this point, I'd have to ask for a third bill.
I think that's a mechanism for us to engage in the conversation. One question for Ms. Reed is, do you think that that's a workable option? So Senator Kolb's, similar to Representative Craig's motion, I think you have two options based on the advice of Mr. Fuller, where you could ask to have an amendment prepared by LSO, which will be available for the committee's consideration for the deletion of Section 7 related to costs. Would you like to do that?
I would do that, ask for amendment prepared
Okay.
to that effect.
Is there a second? I'll second that. Further discussion? Question? All those in favor, please say aye. Aye. Any opposed? None opposed. Okay, that motion has passed. Any further amendments to or discussion on the bill? Representative Rodriguez-Williams?
Thank you, Madam Chairman. Just some word amendments to Representative Craig's substitute bill. Is that what we're calling it?
I think it's not a substitute, but it's an bill number 2. I guess we'll call it for now for purposes. The Crago bill.
Page 5, line 22. See, add spectrum disorder to autism. I have a few more. Shall I continue or?
Is everyone there? Is that, could you restate that?
Sure. So the substitute bill Representative
Craigos bill. Yep.
Page 5, line 22. The word autism, add spectrum disorder.
Okay.
Continuing on page 8, line 18. After the word psychiatric, add psychotropic. So administering psychiatric or psychotropic medications.
Okay.
And if that phrase is used in further areas throughout the bill, I would just make the recommended same
Conforming.
change. Yeah.
All right, moved by Representative Rodriguez Williams, seconded by Co-Chairman Olson. Discussion, question being called. Representative Yen?
Madam Chairman, maybe just a question for the bringer of the motion. I'm confused on why we would only apply this to one bill and not both. Thank you, Madam Chairman.
Since we have 2 bills. You want to apply it to both bills? Or 3, I'm sorry.
No, there's 2 bills and 1 amendment. So I think it's appropriate to do it to both bills. Yes, Rodriguez Williams thinks that's friendly. Great catch, Representative Yen, for consistency. Thank you. Any further discussion on the motion? Question being called. All those in favor say aye.
Aye.
Any opposed? Okay, that motion has passed. Further discussion?
Yeah, Madam Chairman.
Co-Chairman Olson.
This would be a motion to the Crago bill, which is that if it passes, Representative Crago has to go to appropriations with us to defend the state taking the entire expense. 'Cause I think that'll be fun.
Representative Zwanitzer.
I want to make sure I'm on the right page and everybody else is on the right page. What I believe Representative Crago is asking is for completely separate conceptual on payment, regardless if the other bill fails, passes,
Correct.
et cetera. Right? So we're proceeding with the bill before us, making the suggested changes, going to keep working that. Representative Crago's bill can be amended into a new state. If the Reed bill passes, we would amend it in. If it doesn't pass, we could amend it in the current statute as a completely separate issue. So most of the topics are actually going to fall into the main bill that we're continuing to work on. Even though we keep talking that we're amending it into both, but
I have to admit, I'm not entirely clear what you both are trying to accomplish here. So Mr. Fuller.
Madam
It's
Chairman,
important that he understands.
I guess I understood Representative Crago to have an identical bill to the county attorneys.
Correct.
That with the only difference being the cost. And what I'm now hearing is a separate concept. I think, when I presented the 2 options, what I've heard now is Representative Zwanitzer's, being that second option, that it would just be a standalone bill to amend basically 2510-112, which is the cost. And, Madam Chairman, I'm happy to proceed however the committee wishes, but would just appreciate
Clarification,
a
yeah,
very clear direction.
Yeah, I don't understand either. Representative Crago?
Yes, Madam Chair. My initial motion was to amend it into the Reed bill. The county attorneys put a lot of work and effort into bringing us something. And so my idea can work with the Reed bill. So that was my initial motion. I understand what Representative Zwanitzer are saying is maybe we need we would probably need a separate bill draft that
Correct.
would address that. If we decide not to go forward with the Reed
Correct.
bill, we could do another bill draft that would address costs in current statute.
Correct.
I would make that motion.
Okay. So moved by Representative Crago, seconded by Representative Washit. Does everyone understand? Okay. And Mr. Fuller, you're with us? All right. Any further discussion? Question being called. All those in favor say aye.
Aye.
Any opposed? All right, that motion has passed as well. Representative Zwanitzer? All right, any further discussion on this topic? Committee, I will say this on this topic, it's big. We'll have a lot of work to do at our next meeting. So we'll have to be really ready to dig in. And so I would encourage you to ask much of your questions or have them prepared in advance of that meeting. So all of the subject matter experts can be ready to pivot. We've got a clear understanding of where our arms should be around this. I would also just make note, and we can discuss this at the end of the meeting as well, that probably at our next meeting, we should invite a chairman or the chairmans of the select committee for mental health and substance abuse. And of course, we have Representative Provenza as well, but probably out of a courtesy to make sure that they feel comfortable providing us some input about the changes that we've just implemented in statute this past year. So we can hear from them and make sure that the committee isn't layering up on efforts that other committees might be doing, and that we are doing efficient, effective work. So with that, it's 12:25. We'll go ahead and come back for lunch at 1:35. Everyone good? 1:45? I know you guys have a long way to go. 1:35? 10 minutes is gonna make a big difference. We'll do 1:45, come back from lunch. All right, thanks so much.
Long way to go. Where's everybody going?